No, Lordship. Lordship, I beg to mention item number 2. Since Mr. Tiwari is unwell, he is having his own treatment for some Mr. Tiwari. So can the matter be posted coming week?
No, he is sick. Why should we trouble him next week?
No, because other side also we have taken consent. Nobody is here now today.
No?
We have to file affidavit also, Your Lordship, if some time may be needed.
There is a stay order already operating. Since we got to disqualification. There is a stay order. We also filed an affidavit.
Okay. Is prayed for by the Land Council for the appellant, Mrs. Kamal Saxena. List this matter after.
Next week,
List this matter after a week.
2 weeks, Your Lordship.
After 2 weeks.
Lordship, interim order is there.
Okay. Miss, her name is, is also present on behalf of respondent.
Respondent for 1, Lordship.
Take-
Respondent number
1.
1. Okay. No one appears on behalf of the other respondent, private respondent. Okay. The interim order pass earlier shall continue till the next date. Okay.
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 Item number 1.
This is a criminal jail appeal. I've received the paper book.
But do
It is seen that there are 2 accused person in this case. Today is for Sri Raju Sonar, accused number 1, and there is one more criminal appeal, that is a criminal appeal, jail appeal number 28, which is for the other accused, that is Budhe Rai. They could be put up together
Hmm? Just a minute.
because I've received only one paper book for Raju Sonar,
Raju Sona,
accused number 1. Today is for Raju Sonar.
just a minute. This is Budherai only.
there is
What I've seen is. Just a minute.
6.
No, there, what I've seen,
No, there are 2 appeals.
I was there. I went to charge it. So,
Yes,
So one.
it was passed by Your Lordship.
hmm.
None has appeared for respondent number 2, victim.
No,
What we'll do is, I was in the trial court.
My lord
Yes,
had
he-
dealt
yes,
with the matter
yes.
Hmm.
as far as I know.
Okay, then let's,
before any other.
okay. List this matter before any other benches, before one of us. Mine, huh? Okay, any other appropriate bench? Huh?
My lord, I have
Yes.
This was a letter.
Hmm.
These are not there. This is not.
Hmm, but letter is- It says that there is no tax. Yeah.
Not this, it's not there. I'm not very clear. Next. Next. It's not there.
Okay.
May I, my lord? My lord, I have received the paper book recently, so this matter may be fixed for admission hearing.
But the team has to be started. What to do?
So, we need. You have received the paper book.
Yes, my lord, I have.
Argus. Jerome. Legal aid counsel for the appellant. So the additional PP is not present. Additional PP is not present. State not represented. The service upon the respondent number, respondent number 2.
Victim.
Return with the comment that the summon could not be served due to non-availability of victim girl at given address. In view of the above, the the register cum secretary Guwahati High Court Legal Services Committee is directed to appoint a legal aid counsel from the panel of a penal advocate for the Legal Services Authority to represent the victim. Stop. List this matter after 3 weeks. Okay.
May it please, Your Lordship. Well, this is a PL where notices were issued on 21/11/22. Well, our entire grievance is that non-implementation of a defense road in the Indo-China border. Well, the respondents too have filed, and one respondent has been repeatedly taking time. I pray that this matter may be fixed for final hearing, because the issue is whether during the alignment can be changed in derogation to the larger public interest. And since it's a defense road, there are letters of the Defense Ministry also that the road should be constructed early. National defense is concerned. The Deputy Commissioner and the border one wing has given their affidavit. The DC has supported our case. My lord, this may be fixed for hearing, and if anyone wants to file their affidavit, they can file it. We'll give our account.
Okay. Yes.
May I say something, my lord? My lord, this public interest litigation, if you lordship check the background of the petitioners, my lord. One is class 10 pass, one is class 12 pass, my lord. One is a farmer. Then secondly, my lord, they are directly involved in this matter, my lord. They are interested party, my lord. Why in the form of public interest litigations? And if you lordship see the High Court Rule 2011, my lord, I'm sorry, my Rule 10 has been forgotten, my lord. They have not complied with the Rule 10. My lord. And so far, affidavit of government is concerned, my lord, Deputy Commissioner has filed the affidavit. We have said, my lord, we have nothing to do with realignment, my lord. It's to be done by the executing agency, my lord. We are nothing to, we are not concerned with the realignment, my lord. If
My
your
lord,
lordship,
with your lordship's leave, one thing
if
I
your
like.
lordship see, just a minute. If your lordship see, my lord, paragraph 1, page 9, my lord, it says the petition do not have any private, vested or personal interest in the matter present. Petition is not guided by self-gain. Whereas in the petition, a resident of my lord, is the project itself starts, my lord, Tooting, my lord. He's a resident of Tooting, my lord. Obviously, he will be interested party, my lord. Then secondly, if your lordship see, my lord, the another ground, paragraph 3. The present petition has also filed with a view to protect the sovereignty, security, integrity, my lord. I'm proud of my 3 wings of Indian Army, my lord. They are enough, my lord, to safeguard our security and integrity, my lord. Then if your lordship see paragraph 5, this is the background of the petitioner, my lord. One is class 12 pass. Petition number 2 is a farmer, my lord. if there is to be any alignment, realignment, I don't know man, how the petitioner they will be, my lord, deprived of any beneficiary. It's a construction of road, my lord.
Well, time for the respondent number 1, 2, 3, 4, 8, 9, and 10. Madam.
They have not filed an affidavit.
Hmm.
One has filed an affidavit. One has filed
Yes.
affidavit,
In fact, the correspondence is already been made. Madam,
Not yet filed.
not yet filed.
not yet filed. So some more time will be granted. Madam. We'll come with the affidavit. Madam.
We file affidavit, the government also.
My lord,
the
one
copy-
thing I like
affidavit-
to submit as a.
Respondent number 6, my deputy commissioner has filed the affidavit, my lord.
Yes. Madam, the affidavit in respect of respondent number 9 has Madam, filed for stacking of the name of the Madam, the respondent. Madam. They are otherwise Madam, not concerned with this Madam, project work. This is basically Madam, the works related to respondent number 3, 8, and 10. Madam, for the road organization. All other respondents are Madam, not the necessary party.
Yes.
And in respect of Madam, the said respondent, Madam, respondent number 3, 8, 10, we are Madam, filing.
Government of India.
My lord,
Government of India filed it.
That's what I-
We can file. This is the border. You only will have to come and file. Ask them that. Huh? Let them file.
my lord, one thing I like to make a submission as a petitioner. My lord, for the first time in my career, I have seen a submission made by a respondent counsel stating that he is a matriculate pass. My lord, is the Constitution of India, he should specify who should come to the court. 226 is an extensive power. If he's a matriculate, he cannot come, others can come.
No, I haven't said that my matriculation cannot approach
Yes.
the court, my lord.
Yes, sir.
I said just check,
He
check
should
the
not make such
background of the
submission.
petitioners, my lord.
First of all, he should give his affidavit and then make his stand.
That's what High Court rule says, my lord.
Well, the problem with the council is that they want a dismissal on the day of before admission.
Otherwise, my lord,
It
any
is for
time Dick
hearing,
and Harry will,
and
they'll
The
file
learned
affidavit.
council has
PL, my
been
lord.
taking time
This
repeatedly.
is the main problem, man.
The order shows he has been taking time always for the past 9 months.
Mr.
Mala DK Das.
D.K. Das, Mr. D.K. Das, Land Counsel for the petitioners. Also have Mr. M. Kato, Land DSTI for the state respondent number 1 to 4 and 8 to 10.
Fine.
As well as Mr. R.S. Nabam, Land Additional Advocate General representing the respondent number 5,
5, 6 and 7.
5, 6 and
7.
5 to 7.
Five to
Start. Mr. Kato, Planet DSG, I pray for some more time to file affidavit. How much time?
4 weeks time, maybe.
4 weeks, okay. And then government want to file,
My lord, the respondent number 9, that is the deputy commission, my lord.
they
He
have
is the
filed.
main authority concerned, my lord. He has filed, that will suffice, I think.
Okay.
Suffice. The rest may not be.
The prayer is allowed. You, okay, Mr. Hmm. You represent 3 and 8. Okay. Mr. Hmm. No, Kato is,
Kato is 1, 2.
3,
Four.
4, Madam.
hmm.
8.
Mr. Tafo is also appearing for 3 and 8. He's also appearing.
Yes, Madam.
Both cannot appear.
Okay,
Madam,
he is
and-
representing 3 and 8, huh? You are representing this, you are representing. Okay. Standing counsel, other will be.
You are not a, oh, you are not there. RWD is not a party. Not party.
No, no, RWD is not a party. 8 is something else.
There's,
Over the road. Deputy Commissioner additional district.
DRO, ministry,
No, no, RWD is not a party.
RWD.
No, probably you are not party. Okay. The prayer is allowed. List is matter after 4 weeks.
Mala, your lordship will specify that on the last date, they were seeking time as a last resort. Mala, that may be specified. Because on the next day, they will again take time and go for a hearing before the pleadings are not filed. Lordship will just specify that as a last chance, Mala. Mala, the government authority has to respect the judicial orders.
No, which government is? Central government is state government.
Well, sir,
Well, I
you may
am
be
not
allowed to first
responding to
file
the
affidavit, my
respondent's
lord, at
speech.
least, my lord.
Your lordship will specify that because there are 3 orders to the effect that these lawyers have been
It
taking.
is
some
case
day-
of only 2024, my lord. Sorry, 23, my lord. We'll file, my lord.
Let them file, they'll file.
Yes, my lord. Lordship will specify a date, lordship. Because we are outstation lawyers.
They'll file.
Lord, date, lordship is giving a date.
Date
Yes, Lord.
is prayed for by the learned counsel for the party. List this matter on.
No, give a date.
So they want.
Yes, my
date.
lord. Let it be on the 3rd of September. Well, let it be at the 27th of August, Lord.
August, okay,
27.
of August. Okay.
Obliged.
May it please the process. Madam, I have filed an anticipatory bail application today, madam. I will be allowed to move the same today, madam.
As a last item.
As last.
My lord, my lord, I'd like to mention one item, WPC number 335 of 2022. This was WPC number 335 of 2022, mentioned for tomorrow.
When, what is your prayer?
I would like to mention before the court to restate the matter, WPC number 322
When?
for tomorrow.
What is this matter about?
This is a land dispute regarding land dispute, and it was left over matter with last time. So,
Day after tomorrow.
yeah,
Tomorrow's list already prepared. Day after tomorrow. Okay.
obliged.
Item number 28. Lordship, here, we have to file affidavit, your lordship. 3 weeks may be granted, your lordship. I have taken the consent of the petitioner.
28.
28,
Yes.
3 weeks, lordship.
My lord, I am for the petitioner, my lord. Interim may be continued. madam.
You are praying for
For filing of affidavit, your lordship.
affidavit.
Yes, your lordship.
The respondent probably has already filed affidavit. They
Uh,
are to file rejoinder.
Respondent number 5, on behalf of respondent number 5, I have to file, your
Okay.
lordship.
Okay. Mr.
LNOC, my lord.
No, see, that
Yes.
counsel for the petitioner is present. Miss,
Arpa, sir.
learned counsel for the
For
state,
respondent number 1, 3, and 5, 6,
state respondent 1, 2,
5, 6.
5, and 6.
Yes, lordship.
Praise for the time, how much time?
For 3 weeks, your lordship.
Praise for 3 weeks. Time. A further 3 weeks time to file affidavit in opposition. The prayer is allowed. List is matter after 3
3
weeks.
weeks, your lordship.
Stop. The interim order passed earlier should continue till the next date. Okay.
Obliged.
My lord, I beg to mention item number 9, my lord.
Item 9.
Yes, my lord. My lord, here, my lord, I have to file rejoinder, my lord. I have to file rejoinder, my lord.
You have to file rejoinder.
Yes, my lord. 3 weeks time may be given.
Mr. You are Mr.
LNOC.
Learned counsel for the petitioner. Prays for and is granted 3 weeks time to file rejoinder. Stop. You are for respondent?
No.
No, okay. List is matter after 3 weeks. Okay.
Interim may be continued, my lord.
Interim is also there.
Yes, my lord.
The interim order passed earlier shall continue till the next date.
May I please, my lord?
Yes.
I beg to mention item number 16, my lord.
Yes.
My lord, here the CD was called for, my lord. However, I am yet to receive the CD, my lord. I have informed the other side, Mr. Soki, my lord. The matter may be fixed on 18th, my lord.
Who is for the petitioner?
Mr. Soki, my lord. I've informed him, my lord.
Okay, you have informed.
On 18th, my lord. 18th.
18th.
Yes, my lord.
Mr. Ojin Pada, Land SL, Land Special PP, with the consent of the Land Counsel for the petitioner, prays for listing this matter
On 18th, yes, ma'am.
The prayer is allowed. List this matter on 18.
Obliged, ma'am.
Okay.
May I appreciate Lordship? I would like to mention item number 18. This is AV matter. The leading counsel, Tapan Bharti, due to some family problem and issues, is unable to appear this honorable court and may allowed and may fix this matter on 27th of this month. And same is concerned to the PP only, from the PP also.
Okay. Mr.
M. Bagra.
Appearing on behalf of Mr. Tapan Bharali, Land Counsel for the petitioner, prays for listing this matter on
24/7.
24/7, with the consent of the
Yes, PP only.
Land people. Prays for listing this matter on 27. The prayer is allowed. List this matter on 27 accordingly. Okay.
Much obliged.
May I please, your Lordship?
Yeah.
I beg to mention item 25. It appears, Lordship, that this has been wrongly listed because this matter was heard on 27 of May and hearing was concluded and judgment was reserved. This was a DB matter.
Okay.
It was heard by Justice Surana and Justice UK Nair. So I don't know why it's been listed today.
Ms. Nikita Dangan, Land Counsel for the appellant, submits that this matter has wrongly been listed. Yes, with LCR and paperwork.
I have checked with with them. They have brought a wrong file, a different one, not the one listed today. So I don't know. There must have been some mistake.
Okay. So this otherwise it
This
is
may
matter.
simply may not be taken up because your Lordship cannot pass any order in this.
This is DB matter.
DB matter already heard, judgment reserved. That was on 27 of
Okay, that
May.
is wrongly listed.
Yes,
Then so
This
if it is a DB
simply
matter,
may not be
don't-
called.
Don't have to pass any order.
yes.
Okay, just let us see how it is listed then. 25.
There is a different file there that I have.
No, it's name also different.
That was a murder case. This is a POXO case.
No, so 25 is a different case there. Yeah,
In the cost list, it's different.
oh, this is different. Okay. So we'll not pass any order in the Bajum Sidoso.
Yes, your Lordship
this
cannot
file
pass
is
any
also
order in
not
that.
there.
Yeah.
Okay, just simply ignore it, and we have to clarify from the registry how it got listed. So tell them. But then how it is possible? No order passed, huh? 25. And then this, whether this method is fixed. This is also not fixed. Okay. Just ignore it and then confirm it from the registry, tell the registry to bring and tell. Okay.
Obliged.
Yeah, Lordship. Lordship, I beg
Yes.
to mention one unlisted matter. Writ petition number 165/2024 for withdrawal.
Unlisted writ petition.
Yes, sir.
Let it be listed tomorrow.
Lordship, I may be allowed to withdraw this writ petition.
You want to withdraw?
Yes, Lordship.
Which one?
165/2024.
Okay, you want that to be listed?
Yes, Lordship.
Okay. Tomorrow,
Lordship, today itself, Lordship, kindly.
today.
Yes, Lordship.
Why?
Lordship,
Okay.
as per the instruction of my client,
Okay.
they don't want to pursue the matter.
Okay.
Yeah, I beg to mention item number 8.
8. Yes,
I humbly pray for 3 weeks time, Your Lordship.
you are for?
Petitioner. On behalf of Diki Pangi.
Okay. And who is for the other side? Have you informed?
Yes, I have taken the consent.
Mr.
A Gamre.
Your name is there?
No.
Learned Counsel appearing on behalf of Mr. Dicky Pang, Learned Counsel for the appellant, with the consent of the Learned Counsel for the respondent. Prays for listing this matter after 3 weeks. The prayer is allowed, list this matter after 3 weeks. Okay.
Lordship, also item number 31. I am appearing on behalf of C. Fokan. Due to unfortunate demise of the leading counsel's father, he could not be present here today. So,
Your name is there?
no,
Okay.
I pray for 3 weeks time, Lordship.
Petition. There is also private. Have you informed the other side also?
Yes, yes.
Okay. Similar with I think. Mr.
A Gamre.
Appearing on behalf of Mr. C. Fukon, Learned Counsel for the petitioner, with the consent of the other side, prays for listing this matter after 3 weeks. 3 weeks?
Yes.
Okay. The prayer is allowed, list this matter after
Obliged.
3 weeks.
Yeah, my lord. My lord, I beg to mention item number 14, my lord.
40.
I'm for the petitioner, my lord.
14.
Yes, your honor.
Make appeal. Yes.
My lord, this matter may be listed after 3 weeks, my lord.
You are for
A petitioner, my lord.
insurance.
Yes, sir.
Your name is there?
Yes, yes, my lord. My name is there. NUB, my lord.
Okay. Mr. NUB, Learned Counsel. Have you informed the other side?
Yes, my lord, I am from the respondent.
Okay. On the prayer of both the Learned Counsel for the parties, list this matter after
3 weeks, my lord.
3 weeks. Okay.
All right.
Your Lordship, if may I please. I'd like to mention item number 30.
Item
30.
30.
Yes, sir. Yes, Lordship.
Yes. Make it.
This case may be listed after 2 weeks. Lordship.
After
2 weeks.
you are for? Hmm? Please, in the mic.
Pardon, Lordship, we have an objection regarding adjournment of item number 30, or my lord.
30. You are for?
I am for the respondent number 1, Lordship. This matter has been pending for quite some time for this stage of hearing, my lord. So we are objecting to the adjournment, Lordship. It may be taken up, Lordship, when the matter is called.
Your name is there?
No, no, Lordship.
No. Who is the main counsel
Tea time.
for the appellant?
The appellant counsel was here this morning. I met him.
Supplementary hearing. Why you want adjournment?
The counsel for the respondent is out of station, Lordship.
Counsel for the petitioner?
No, respondent.
Respondent?
Yes.
Oh, sorry, you are for respondent. Okay. So in absence of counsel, it will be difficult.
That is their, Lordship, but we also want a specific order because, Lordship, this case has been pending at the stage of this hearing. It has been repeatedly adjourned, Lordship. So we are facing difficulty because there is a stay order, my lord. So if some order may be passed in regard to the stay, we don't have any issues. But due to the stay order, for more than 1 year, the proceedings have been stopped because the award has been stayed by this.
You are for the petitioner, huh?
I'm for the respondent number 1. I'm the owner of the vehicle. I'm the claimant.
Respondent.
The person would be the insurance company, respondent number 2.
No. You are for respondent
Number 2.
The insurance company.
insurance, and you are for private respondent.
Yes, private respondent.
Who is for a petitioner?
The petitioner, the appellant, the counsel was here.
Appellant.
Yes, the counsel was here this morning. So so this matter may be taken up, Lordship, that some manner of order regarding the stay may be passed because we are facing difficulty, Lordship, because of this repeated.
There is a stay.
There is a stay operating against the award, Lordship. And because of the award, we are unable to execute the award, Lordship, for more than 1 year, Lordship.
whether they have deposited the
Uh,
awarded amount?
no, Lordship, no deposit has been.
No order.
Yes, Lordship. So, Lordship, these aspects may be taken up, considered, and when the matter is called up, Lordship, in due hearing, Lordship. Our prayer, Lordship, if it can be considered, Lordship.
Let the matter be, anyway, wait for some time then. Wait for some time. Okay, let us see the record. If the stay can be vacated, let us see. Okay, if there is no deposition, let us,
Much obliged.
okay. Obliged.
I would like to mention item number 26.
26.
Yes. There is instruction from my client to this, withdraw this matter.
You want to withdraw?
Yes, saying that they wanted to resolve at personal level. This is actually land dispute matter. They wanted to settle the matter at personal level.
Okay. Mr. T. Tapak. Yes, you have any objection?
No, Lordship. I'm
T.
keeping-
Tapak, Land Counsel for the petitioner. Wants to withdraw this criminal petition. Miss Alhage, Land Counsel for the.
I'm for the state, Lordship.
TP. For the state. Has no objection. The prayer is allowed. This criminal petition is dismissed on being withdrawn. Okay,
Lordship, with the liberty to file fresh if necessary.
with liberty.
Letter, yes.
Okay. Pray for, want to withdraw with liberty withdraw, with liberty to withdraw, And in the last, dismiss on being withdrawn with liberty is prayed for. Okay,
Right.
yes.
May I please, your Lordship? My lord, item number 1, 2, 3, 4, and item number 23, my lord, out of the same case diary, my lord.
1,
2, 3, 4, and item number 23. Bail hearing, my lord. And item number 23, my lord, CD was called for, my lord. Connected matter, my lord.
Lordship,
Out of the
1
same
to-
case diary.
1 to 4, Lordship, they have this a new case, Lordship.
New case,
The CD may be called for, Lordship, for this case for separately.
But my lord, in item number 23, out of the case, same case diary, my lord. So in item number 23, my lord, all are out of the same case diary, my lord, out of the same PS case, my lord. So my lord, in that case, my lord, item number 23, CD was called for, my lord. So my lord, out of the same case diary. Item number 23, my lord. Pasigat case number 77, and in these four cases also, my lord, Pasigat case number 477. So in that case, my lord, case diary was called for, my lord. So if case diary received, my lord, then all the matters may be heard, my lord.
Whether in item 23, case
Lordship,
diary
case
received-
diary under 23 we regard in the item 23, it has come, Lordship. But 1, 2, 3, and 4, Lordship, this is out of same PS, Lordship, but the case diary has come, we have called for Lordship, item 23 only.
No
So,
problem.
Lordship, in this matter, Lordship, it may be called next
No
week,
problem.
Lordship.
No problem,
Otherwise,
because my
Lordship-
same case diary, my lord. Case diary is one, my lord. So in this cases, my same case diary, my lord. So there is no different case diary, my lord. One case diary, my lord. The different case diary will not come, my lord. That is why, my lord. All,
whether the investigation and the statement of all these.
my lord, all will be there because one case diary.
petitioner-
Lordship, how can he say?
Petitioner in the item number 1 to 4 are also covered in the.
Yes, my
case
lord.
diary?
It will be covered.
Yes, sir, Lordship, I have to go through, Lordship, because the case diary just this morning only I have received, Lordship,
Okay.
and therefore the item number 23.
Because, my lord, statements of all the accused persons will be there, my lord, because case diary is same, investigation is same, my lord.
Okay. Along with 23, let us see that.
My lord, my lord,
Along
my
with
lord.
23.
Then in
my
the
lord.
meantime, I'll
Let
go
the
to
matter
the-
call for.
Lordship.
My lord,
Matter be called for.
my lord. In the meantime, my lord, landed friend will, my lord, read my lord.
Okay.
My lord, obliged.
Next item, 5.
My lord, may I?
Yes.
My lord, this is connected with Nagaland PS case 55. The NDBS case, your honor. My lord.
Yes.
So arrested, my lord, in this case, there may be called for. No charge sheet. No charge.
Otherwise-
Actually, your allegation is against only is 25 only. That allegation is that I have allowed my room to this one sell the NDPS or this contraband substance. That is only the allegation. Your Honor. And
Okay, we'll issue notice, call for case.
Call for the case diary and fix after a week, your lordship.
Mr.
J maybe. J maybe.
J,
Yes, maybe. MEBI.
maybe, Learned Counsel for the petitioner. I've also heard Mr. Yete, Learned additional PP, State of AP staff. This is an application under section 439. Of criminal procedure. Is it okay 439 now?
Yes, your lordship. 439 is the right provision because this case was registered prior to the implementation of the
Yes, yes,
BNSS, and the
Yes.
same will not have a retrospective effect because saving clause is there, your lordship.
Okay, praying for release of the accused who has been arrested in connection with Nahalagan PS case number 5524 under section 21B/25/27 and 29 of NDPS Act 1985. Para, call for the scanned copy of the trial court. No. Scanned copy of CD. Case study, no?
Yes, sir.
Okay. So list this matter,
Your Honor, on of 24th of this month.
24,
Yes. Sir.
as a fixed matter.
Yes, your lordship,
Okay.
fixed matter because
List this matter on, is prayed for by the Learned Counsel for the party. List this matter on 24th. Okay.
Privilege.
Nibly obliged. Your lord, at the outset, your lordship, I would like to make objection on the provision invoked by the petitioners, your lordship.
Lordship, in matter to that, earlier I had filed under 482, but on instruction of the filing section, we have changed it to the new BNSS. If that is one of the other copies with me also that we can annex, but because of, since one of the earlier we had filed it under section, this is a joint washing petition. So we had filed it under 482 inherent power of the court of High Court, but Lordship, since there was an objection saying you have to file it under the new provision of law. So on that we have changed now. That is not, that is.
There is no standing notification as such as on that, your lordship, from the from our High Court. And so far as your lordship, the provision is concerned, as your lordship, I have already submitted before your lordship yesterday also, the old code will prevail, your lordship. And section 4 also can be looked into, your lordship, where everything is clear. Otherwise, your lordship, the procedural law have a retrospective effect, no doubt. But the legislative intention is clearly there in the saving and repeal clause, wherein, your lordship, it has not been given retrospective effect. So otherwise, your lordship, if all this is implemented, or if they are allowed to invoke BNSS, your lordship, then, your lordship, in the pending matter also, your lordship, the procedural law will be there. Trial pending also, the procedural law has to be there, if it has been given that effect. Your lordship, I have indicated the 531 of the saving clause, and your lordship may again see the section 4 of the BNSS again, your lordship. Your lordship, section 4 of BNSS, your lordship.
In that matter, Lordship, the registry has to issue a notification saying, but
has
since
to be
from the
probably
4th
has
of
to be
July,
issued
there's a no.
from the principal bench.
From, there isn't.
It requires, your lordship, judicial interpretation. Yes, section 4, your lordship, may come straightly, and then, your lordship, saving and repeal clause is also there. Section 4 of BNSS, your lordship.
No, this is BNS.
No, Bharatiya Nagrik Suraksha Sanhita, BNSS.
BN.
So, Lordship, there is a technical issue that if some senior may be called away on whether to file it in whether the new BNSS will trigger
Section,
over on.
Your Lordship, the provision is very clear, Your Lordship. The provision in saving clause, Your Lordship. Section 4, Your Lordship, may I read out, Your Lordship?
Just a minute. Yes.
Trial of offense under BNS, Bharat Nyaya Sanhita, section 23, and other laws. All offenses under Bharat Nyaya Sanhita 2023 shall be investigated, inquired into, tried, and otherwise deal with according to the provision herein contained. Now, subsection 2. All offenses under any other law shall be investigated, inquired into, tried, and otherwise deal with according to the same provisions, but subject to any enactment for the time being in force, regulating the manner or place of investigation, inquiring into, trying or deal and such offense. Now, Your Lordship, the IPC is not in existence. And the subsection 2 doesn't cover the IPC provision.
Now, this was registered, the case was registered.
Prior to the commencement of the
Prior to
new code. And Your Lordship may directly again come to the this repeal and saving clause itself, Your Lordship. Because legislature intendment is clearly there. Legislature has not intended to give it a retrospective effect.
Not retrospective, cancel.
531, Your Lordship, of BNS. It's very clear, Your Lordship. Subsection 2.
Yes.
A. And Your Lordship, no doubt, this Sanhita has not been discussed in the Parliament, but the Honorable Home Minister of India has also clarified, Your Lordship. In the paper also it was published, Your Lordship. May I read the operating motion, Your Lordship? The Code of Criminal Procedure 1973-2 of 1974 is hereby repealed. Now, non-obscenity clause, notwithstanding such repeal, if immediately before the date on which the Sanhita come into force, there is any appeal, application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as case may be in accordance with the provision of the Code of Criminal Procedure as in force immediately before such commencement. Herein after refers the code as if Sanhita has not come into force. So the repeal section code were not destroyed, Your Lordship, in entirety, Your Lordship. The saving clause has been given and it is clarified that if any pending investigation, Your Lordship, with the commission of the crime, an investigation, if it is registered, then all the subsequent developments are pending. If investigation, if suppose case is registered, then its inquiry stage is pending, appeal, trial stage is pending, appeal stage is pending. That has to be interpreted in that manner. And it doesn't say pending before the court. It says pending, Your Lordship. Simply says pending. And Your Lordship may now come to the clause C, Your Lordship, C, where again the legislator has used the term may, not shall. Any sanction accorded or consent given under the said code. This is the precognizance stage, Your Lordship, sanction, precognizance stage, in pursuance of which no proceeding has commenced under that code shall be deemed to be accorded. Now here it said shall deemed to be accorded or given under corresponding provision of the Sanhita. And proceeding may be. Now here it says may be, Your Lordship, is the discretion of the court commence under this Sanhita in pursuance of such sanction or consent. Now here the discretion has been given to the concerned court, trial court, whether it has to be tried in accordance with the Sanhita or with the old code, Your Lordship.
Whether for implementation, whether the High Court notification required anyone.
It's required. It's not there, but required, Your Lordship. Your Lordship, the Punjab High Court has rendered one judgment, Your Lordship, in this regard. But pertaining to the fact of that case was, Your Lordship, the application was filed, the revision petition, prior to the commencement of this act. And on that they filed an application under Limitation Act, wherein it has been held that when the matter is condoned, then it will be, inference can be drawn that the revision has been filed on the day of the expiry of the limitation date. And if that date fall prior to the commencement, then, Your Lordship,
this old code has to be followed, Your Lordship. And Your Lordship, so far as this repealment is concerned, the judicial pronouncement is also there, how it has to be dealt with when the procedural law or substantive law is repealed. If Your Lordship allow, I would like to realize a full bench judgment of the Punjab High Court, Your Lordship. Your Lordship, I will realize the judgment, but unfortunately, this code was not gone through the Your Lordship discussion before the Parliament. But this issue was also placed before by the media, by the Your Lordship Home Minister of India, where it has been clarified. I will come to that, Your Lordship. Now, this is the case law, the full bench by the Punjab High Court dealing with such situation, Your Lordship. It's in 1958 AIR, Punjab and Haryana High Court, 230 page, Your Lordship. Full bench judgment. Your Lordship will directly come to para 3, Your Lordship.
Just a minute.
Para 3.
It was decided on?
Para 3, Your Lordship. It's a all judgment, Your Lordship. In 1958, Your Lordship.
Yes.
It is well settled rule
Para?
Para 3, Your Lordship.
Okay.
On Par's page itself.
Yes.
I will rely 3, 4, 8, 9, and 10. Here, Your Lordship, the Company Act was repealed, wherein the jurisdiction of the district court has been taken away, Your Lordship. It is well settled rule of common law that when an action is brought under a statute which is afterward repealed, the court loses jurisdiction of such suit pending under the repealed act and is unable to deliver judgment therein. The effect of repeal a statute is obliterate it has completely from the record of Parliament as if it has never been passed, and it must be considered as a law that never existed, except for the purpose of those actions which were commenced, prosecuted, and concluded while it was existing law. It follows as a corollary that if a statute is unconditionally repealed without a saving clause, now here, Your Lordship, unconditionally repealed without a saving clause in favor of a pending suit, all action must stop. Where the repeal find them, and if final relief has not been granted before the repeal goes into effect, it cannot be granted afterward. If saving clause is not provided, then it goes, Your Lordship. A simple principle applied to a law conferring jurisdiction, and it has been held repeatedly that repeal of a statute giving jurisdiction to a court deprive it right to pronounce judgment in a proceeding previously pending. This principle has been stated with the amicably clarity in the case of Hunt versus Jennings, where Blackford Justice expressed the view that whenever a statute from which a court derives its jurisdiction, in particular case is repealed, the court has no right to proceed under the repeal statute, even if suit pending at the time of repeal, unless the right is expressively saved by repealing act or by general act regulating repeals. To mitigate this harsh rule of common law, the legislature considered it expedient from time to time to enact saving clause, which expressively provides that whenever a statute shall be repealed, such repeal shall not affect pending action found thereon. And now, Your Lordship, may direct come to para 8, Your Lordship.
Yes.
The second saving clause is embodied in Section 6 of General Clause Act 1872 and is a part of every act passed by central legislature in the same way as if it were expressively enacted in the body of the act itself. It has been applied specifically to the proceeding under the Act of 1913 for Section 658 of the Act of 1956 declared that the mention of particular matter in Section 645 to 657 or any other provision of the latter act shall not prejudice the general application of Section 6 of the General Clause Act 1897 with respect to the appeal of effect of repeals. Section 6 of the Act of 1897 provides that in every central act passed after 1897, unless a contrary intention appear in the repealing act, the repeal shall not affect any investigation, legal proceeding, or remedy, and that any such investigation, legal proceeding, or remedy may be instituted, continued, or enforced as if the repealing act had not been passed. Or, to put in a slightly different language, this provision declared that proceeding which were commenced by virtue of the statute which has been repealed shall not be dismissed by court for want of jurisdiction after repeal of that statute as under the common law, but that said proceeding shall be continued to be dealt with by the court as before and shall be carried to final judgment and execution by said court in exactly the same way as if the statute has not been repealed. It is common ground that proceeding relating to the winding up of a company are legal proceedings, that these legal proceedings were pending in the court of district judges at the time of repeal, and that in the view of the provision 6 of the General Clause Act, they are completely unaffected by repeal. It seems to me, therefore, that it is within the competence of the district judge in whose court the said proceedings were pending immediately before the commencement of the Act of so and so to decide them according with the provision of the Act of 1913. Nor can it be said that the Act 1956 operates retrospectively and applies automatically to the pending proceeding. For although the legislature has the power to give statutes retrospective operation, yet it to be presumed that the legislature intend the statute enacted by it to operate prospectively only and not retrospectively, unless the intention of legislature to make the statute retrospective is stated in express term or is unambiguously shown by necessary implication. This is nothing in the language of Section 10 of the Act which would impel the court to hold that the said section was intended to be retrospective. In view of the case, it seems to me that the Act of 1956 would have no effect on litigation pending at the time it was enacted. Now, Your Lordship, even in the saving and repeal clause, it says the pending cases, the pending investigation, appeal, inquiry, these all are the stage of an offense. If an offense is committed, the stage is initially investigation. When investigation is completed, charges is filed, that is inquiry stage. And again, after inquiry stage, Your Lordship, the pre-cognizance stage is there, and pre-cognizance, post-cognizance, again, Your Lordship, framing of charge, after framing of charge, trial stage, after trial, it is the appeal. So with the pendency of the investigation, entire subsequent proceeding is pending. And here in the saving clause, it says pending proceeding, Your Lordship. Meaning thereby, once a crime is committed prior to the commencement of the offense, then its subsequent proceedings will construed as pending, Your Lordship. Not pending before the court, but the subsequent proceeding would be pending with the institution of the case, Your Lordship. And it says when it is pending, then all act will be followed, Your Lordship, in BNSS. So therefore, Your Lordship, the offense which has been committed prior to the commencement of this code, and even the offenses which has been committed prior to the commencement of the code, but registered later, all that offense will be governed by the Code of Criminal Procedure, not by the BNSS, Your Lordship. Because, Your Lordship, in BNSS, there are substantial changes are there, Your Lordship. If they are invoking BNSS, then 187 will also apply, Your Lordship. That is regarding the investigation process, Your Lordship, where, Your Lordship, the time for police custody has been extended, wherein, Your Lordship, the earlier, where the minimum punishment for statutory period was 10 years, that has been extended to 10 years. Even for that, the 90 days will be the custody for police for investigation. All that has to be, they cannot pick and choose. If they are invoking BNSS, then they have to invoke entire procedure part. Your Lordship. Yes, Your Lordship. And Your Lordship, just for reference, it is no relevancy otherwise, Your Lordship. This question was put before the Home Minister of India because, Your Lordship, this act was not discussed in the Parliament, Your Lordship. Otherwise, the discussion of the Parliament can be produced, and from there, Your Lordship, intention can be drawn, Your Lordship. It's, Your Lordship, the second page, Your Lordship. This is the extract of the Hindu Times, Your Lordship. Here, Your Lordship, relying to a question on ambiguity on which law would be tried for pending cases, Mr. Shah explained, if the date of crime is before July 1, 2024, then it will be tried under old laws. If it is later, it will be tried under new laws. He also said it might take 3 to 4 years for all the laws and technology upgrade to be implemented. Since, Your Lordship, this was not discussed in the Parliament, Your Lordship.
Because if it is so, then you see the appeal also will be governed by the
CRPC. Yes, exactly, Your
It
Lordship.
will not only take 3 to 4 years, it will take more.
Yes, Your Lordship.
It might take more also.
It will take more than, Your Lordship, 10 years, I think, Your Lordship, in my humble understanding, Your Lordship. So both the procedural law will be go parallelly, Your Lordship. For the offenses prior to, no, that is the difficulty for the prosecution side also. We have to go through both the procedural law also. But, Your Lordship, this is the intent of the legislature, where both the procedural law and the substantive law will go concurrent.
Yours is still under investigation, and probably it will govern by the CRPC.
Lordship, if that honorable court feel that Lordship, I have to file it under the all Lordship, since I had filed it before in 482, but on instruction of the filing section, I had changed it, it's ready here only. So I may allow to withdraw that, the page number 1 and the synopsis, that's all.
Under the circumstances, it will be better.
And the matter may be taken up tomorrow, Lordship.
And your lordship, the preceding this bail application was filed under 439. The registry is allowing it. Otherwise, they ought to have filed under VNSS only. 439 they are allowing, and they are not allowing 482, your lordship. And there is no any notification as such.
There is some difficulties. The registrar should also confirm.
Yes.
From the Registrar General principal seat.
Yes.
I had filed it
Whether
under-
there is any notification. Okay, no problem. So you want to withdraw?
No, Lordship, I may just allow to annex the first page and the synopsis. That's all, Lordship. Since it's ready, I've already, everything is ready. I just may allow to take out the page number 1 and the synopsis and annex. And the matter will be taken up tomorrow, Lordship.
Mr. V. Jamo, Land Council for the petitioner, prays for allowing him to correct the provision and replace the course title of the bail application of this criminal petition. The prayer is allowed. The registry shall do the needful. Page, break, comma, list. Thereafter, let it list.
Yes, Lordship.
Okay. Okay, list this matter again. Tomorrow?
Yes, Lordship.
Okay.
Deep Lord.
Your lordship, this is the yesterday matter, your lordship, the anticipatory bail, well, the same issue was there regarding BNSS. So.
Okay. So here also he need to withdraw.
Yes, your lordship.
Yes.
Item number
Yes.
7, Lordship. Lordship, I have one submission, Lordship. Lordship, on 3/7/2024, Lordship, in a bail application, this Honorable Guwahati High Court in case number 1978/2024 passed an order for directing to correct the cost title by inserting the provision of DNSS, Lordship. But in virtually I cannot send the order, Lordship. But in bail application, case number 1978 on 3/7/2024, Lordship. Justice Eddie Chaudhary has passed an order, Lordship, regarding invocation of BNSS, Lordship.
What is that order?
3/7/2024, Lordship. Bail application number 1978. Lordship directed to rectify the cost title by inserting the provision of BNSS, Lordship. Lordship, I have mailed the order, Lordship.
Yes.
Whether your lordship, there is a specific interpretation on law by this coordinate bench or not, that has to be looked into, your lordship.
We need to see that order. Yes, Land Council.
Yes, Lordship, I have sent the order to the email of the Honorable Court, Lordship.
Can you give me the number of
what it says?
May I read the Lordship? Yes.
Please.
The learned counsel for the petitioner. Just a second, Lordship. Yes. Pardon, Lordship. I'm searching.
Yes, please.
Yes, Lordship. heard Mr. M.A. Learned Counsel for the petitioner, also heard Mr. S.H. Bora, Learned Additional Public Prosecutor for the state. The Learned Counsel for the petitioner is permitted to correct the post title in as much as it is submitted date. The post title, the application is mentioned to be under section 439 of Code of Criminal Procedure 1973, whereas this ought to have been an application under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023. However, such correction may be made as per extant norms. The accused petitioner so and so have preferred the present application praying for granting regular bail, who were arrested on 31/5/2024, that is prior to the implementation of the law, in connection with Hatigaon PS number 116/2024, registered under section 120B 420/406 387 of IPC. So list the matter accordingly. Lordship, the Honorable Court directed to correct the post title, Lordship.
The case was registered when what date you said? Case
Date
was
is,
registered.
Case was the person was arrested on 31/5/2024.
Okay, so I think we are going
Your Lordship,
different way.
Your Lordship, that is the issue, Your Lordship, here, Your Lordship.
Hmm.
Your Lordship, that coordinate bench has not discussed this repeal and saving
Yes,
clause, anything.
that is why.
That is the reason, Your Lordship.
Probably-
And we cannot go like
probably
this. Your-
The High Court need to issue some notification,
Yes, Your Lordship.
uniform implementation.
Yes, Your Lordship. Because Your Lordship, now we are objecting on that, Your Lordship. Your Lordship has to look into the provisions and interpretation is required because Your Lordship, this is just a case with all respect to the coordinate bench. In a casual manner, it says the number be changed, the course title be changed.
You send the order, we'll see.
Yes,
You send
Lordship,
the
I have
order
sent the
by
order.
email and we'll see. Okay? So
Okay,
let's
okay.
wait for by the Learned Counsel for the petitioner. List this matter again on Thursday.
Yes, sir. Deeply obliged, Your Lordship.
Item 10. Okay. Yes, yes. Sir. Yes, item 10. No one appears on behalf of the parties on call. Case stand adjourned. List this matter after 2 weeks. Make it
My
3
lord,
weeks. Huh?
my lord, with all respect, my lord, my lord, I have some problem now. Item number 19, my lord, may be taken up at 2 p.m., my lord.
Your Lordship, the accused were directed to file affidavit. Your Lordship, remember that in one bail application, 3 accused were filed, the bail petition.
Okay.
Your Lordship has directed them to file affidavit, Your Lordship. And they, without ascertaining the reason why they unable to swear the affidavit, they filed the bail petition.
Yes, my lord. At 2 p.m., my lord.
At 2.
My lord.
Okay.
Leave it to Your Lordship.
Now after the matter is over, huh? It's the last matter. It's the last
My lord.
item.
My lord, my lord.
Obliged, Your Lord.
Deeply obliged.
Okay, this after 3 weeks, huh? Yeah.
My lord, I am put a petitioner, man. My lord, I may be allowed a 2 weeks time to file additional affidavit, man.
You are for
I am put a petitioner, man.
petitioner. You want to file additional,
Yes, additional affidavit.
not affidavit in reply. Probably you prayed earlier for filing affidavit in reply. You want to file additional affidavit?
Additional affidavit, man.
Okay. Mr.
M. Doshi, my lord.
Learned counsel for the petitioner who was praised for 2 weeks' time to file want to file additional affidavit,
Additional affidavit, my lord.
additional affidavit
Yes.
and praised for 2 weeks' time. And what about this? You earlier you prayed for,
Yes, Your Lordship, they have been praying for filing of rejoinder since
Hmm.
2023.
you wanted to file affidavit in reply. Are you filing affidavit in reply?
This is for the 5th time.
Hmm?
This is for the 6th time they are.
Yes.
doing that.
Hmm.
In the meantime, my lord, if required, my lord, affidavit in reply also file me. Will also,
Affidavit and reply also.
yes, my lord.
So the what you wanted to file by way of affidavit, additional affidavit, it will not
Additional-
cover in the
I'm-
affidavit in reply,
I am praying for additional affidavit, my lord.
additional affidavit,
Yes, my lord.
not affidavit in reply.
If required, my lord, I will file a rejoinder or someone. At the same time.
So
2 weeks may be given.
if you are filing rejoinder, why additional affidavit? Okay, Mr.
M. Doshi, my lord.
Pray for further how much time you said?
2 weeks, my lord.
Further 2 weeks time to file affidavit in reply. But it appears that you have taken earlier also 2, 3 occasions,
Yes, Your Lordship, this is for the 6th time.
6 times.
Hmm.
You are not filing affidavit in reply, but you want to file additional affidavit.
This is for the 7th time, Your Lordship.
The land counsel for a petitioner also wanted to file additional affidavit if necessary, if so required.
Yes, my lord.
You first file affidavit, rejoinder or the affidavit in reply. Thereafter, if required, you file additional.
Okay, my lord.
Okay, that will do a further time, 2 weeks time. And Miss Sangeeta, counsel for the
And for 1 to 5, Your Lordship.
1 to 5 is also present. Okay. List this matter after 2 weeks.
After 2 weeks.
Right.
All right.
My lordship,
Yes.
lordship, leading counsel Master V. Picha is appearing in the court number 2, lordship. Matter may be passed over for time being, lordship.
Pass over for time being.
Lordship.
Okay. Yes.
Your Lordship, this is a transfer petition filed by the wife seeking transfer of divorce petition, case number 04/2022, which is pending in Honorable Court District and Session Judge in Konsa, Tirap, to competent jurisdiction, Honorable District and Session Judge of UPI, Your Lordship.
Why?
Your Lordship, both the party are here only. They are residing here. You may see the page number 18, Your Lordship. The divorce petition filed by the husband. Page number 18. 18, filed by the husband. In the matter of.
Just a minute, sir. Whether the opposite party appeared,
Sorry, sir.
whether The respondents. How many respondents?
Only one husband is there. It's a divorce petition filed by the husband in Konsa District Session Judge.
You are for respondent, yes. Okay.
Your Lordship, page number 18.
Page 18. Have you filed affidavit in opposition?
Yes, they have already filed.
Already filed?
Yes.
Okay. Yes, 18.
Yes, page number 18, Your Lordship. In the matter of Sri Avo Kanham, so and so, the present address, Your Lordship, care of SSB, Fire and Emergency Service, Nodal Officer, Headquarters, State Disaster Response Force, Chimpu, Itanagar. So he is also here, Your Lordship, in Itanagar. His present address is here. He himself mentioned in his divorce petition, the present address. And my client is also here, Your Lordship. The wife is also here. Since the Konsa is very far from here, it takes around 7 hours, 30 minutes, Your Lordship. So it is very difficult for her to travel there to attend the matter, Your Lordship. They have filed this petition just to harass my client mentally, physically, and monetarily. In fact, Your Lordship, one case is already pending here in JMFC UPA court, the maintenance case. We have annexed it in our petition. It's in page number 57, Your Lordship.
Before UPI?
Yes, Your Lordship. Page number 57.
Page?
Page number 57, annexure number 5. May I?
Yes.
In the Court of Judicial Magistrate First Class UPA, Capital Complex Arunachal Pradesh, maintenance case number 4/2023. Your Lordship, this matter is already pending before the UPA or this JMFC UPA, Your Lordship. So already this matter is going on. And in fact, both the parties staying here only, and their kids, they are also studying here in Itanagar only, Your Lordship. It is evidence from their petition, Your Lordship, the divorce petition. It clearly stated in page number 20 of our petition, page number 20, para 5. Page number 20, para 5.
20.
Yes, Your Lordship, page number 20, para 5.
Yes,
May
what
I?
is there?
That the petition begged to state and submit that from their wedlock, 2 male child were born, namely Sri Ashok Kanham, 16 years old, and presently he is studying in class 10 at Government Secondary School, Chimpu, Itanagar. And Sri Panjim Kanha, 12 years old, and presently he is studying in class 6-8 Little Flower School, Chimpu, Itanagar. So both are studying here only. In fact, the father is also here. He is already working in SSB as a constable, and my client is also here, Your Lordship. It is very difficult for her to travel. In fact, I would like to refer one case, Your Lordship, one judgment, which has been passed by the Honorable Supreme Court. It is Supreme Court cases 237, 2005. Rajini Kishore Pardesi versus Kishore Babulal Pardesi, Your Lordship. In para number 4. In this type of matter, the convenience of the wife is to be preferred over the convenience of the husband. This is a relevant point, Your Lordship, the page number 4, point number 4. So, Your Lordship, my client is not a working person. That's why we have to file the petition, maintenance petition. In fact, domestic violence has been filed in this UPA court only before the JMFC in the CJM. In that case also, they have made settlement as by the respondent that like take out, withdraw the case, whatever happening between us, we will settle outside the court. Because of that, only my client withdraw the case. But after withdraw that case, they have filed this divorce petition in their Konsa, whereas they both are staying here only just to harass her. And he knows very well that my client is not working, the petitioner is not working at all. That's why we had to file the maintenance, and maintenance is already going on. I have shown you the order copy of the
Where is
JMFC.
your address?
Your
Have you
Lordship,
given your address?
my address.
In page 18, your address is at Longding.
So, Your Lordship, this is filed by them. Page 18. This is a divorce petition filed by
Where is
them.
your present address?
Yes, Your Lordship, I'm staying.
Page 2.
Yes, sir. It's not my present address. It's here only. Resident of B and Colony Chimpu, Itanagar District, Papumpare, Arunachal Pradesh, Your Lordship. It's in the page number 2 in my petition, first page. Second page. Your Lordship, already case is pending here in JMFC court, UPR.
So where have you stated in your petition
Uh,
that the case is pending before the JMFC UPR and the husband is staying in, the husband as well as you are staying in Itanagar?
It's in page number 8, Your Lordship. Page number 8. It's A, 15A, para 15A. Page number 8 of our petition, para A. May I? That it is pertinent to mention that petitioner having no source of income and being destitute by the respondent financially, the petitioner filed a maintenance case against the respondent bearing maintenance case number 4023 in the Honorable Court of Judicial Magistrate First Class Capital Complex at UPR in the month of February 2023, Your Lordship, and was listed on.
Where have you stated that the domestic violence case also was filed?
Yes, Your Lordship. It's in page number 7. Page number 6, Your Lordship, in para number 12. Para number 12. May I? That pursuant to the that domestic violence case number so and so under section 12 of the Protection Act, Women from Domestic Violence Act 2005 was listed on dated 28/10/2021. But the respondent husband cleverly yet decided the same by entering into a family settlement dated 26/9/2021. Accordingly, the petitioner having fed upon the respondent and being a mother of 2 sons, the petitioner withdrew the aforesaid domestic violence case. And this case has been registered in 2021, Your Lordship. We have annexed this also, the order, this order copy of the JMFC, Your Lordship.
Okay. Yes. Have you filed objection?
Yes,
What is the objection?
Lordship, first of all, Lordship, the petitioner has failed to make out any proper address, Lordship. In the paragraph 17 of my affidavit, I have clearly stated that the petitioner has left from this matrimonial home and leaving aside all those children and her husband. And she is seriously involved in the adulterous activities in the Itanagar Capital Complex. As per the tracking, Google, as per this IP address of Google, this Google map, her address is located somewhere at the Upper Siang Yingkyong. And the petitioner has this filed this application in the name of this present address. Lord, this is not proper address. Whereas she has shown that she is residing at Simpu. She is no more residing at Simpu. Mihi Kanam is resident of DN Colony Simpu, POPS Itanagar. Whereas since, I am to say, since 22 March 2022, complainant deserted all those family members and left the house matrimonial home and residing somewhere in undisclosed location. And first of all, the petitioners and the respondent is permanent resident of Nosia, which comes under the district court of Ponsa. And this petitioner is, he has been posted, he is posted here now. And he may be posted somewhere, anytime. It is, he is just awaiting the government order. At any point of time, he may be posted. That is why trial of the case may be prolonged. In that situation, he has better choose this jurisdiction place of trial at the where they permanently resides, both the parties, husband and wife resides. And on the ground of adulterous relationship with so many male partners, that application that divorce petition is in file. That is the ground is adultery. That is the reason. And when the petitioner failed to prove his address, whereabouts, his present location, in that case, it is not proper to this transfer this case at the Itanagar jurisdiction. Whereas they are having proper jurisdiction at that own place.
But she has filed against you.
Yes,
Maintenance as well as
maintenance,
for the on the Domestic Violence Act also before this UPR only. You have faced trial. You are facing trial here at UPR.
That is another thing. Maintenance case can be filed where the person resides, where the claimant resides, and the domestic violence case also. That is the jurisdiction.
That also.
But in this case, this is a jurisdiction issue again. I have filed a case where I am this as per my conveniences, because I can be posted anywhere. I'm an IR constable under IRVN.
You yourself says that you are being posted here.
Yes, I am posted here.
Then-
I have been staying here since many years.
Then why you want to file there?
I have filed at my permanent place at the under the district court of this Counsel.
Why?
Because it is all the time I have to come and go. That is my place of residence. Usually I come and go.
You are in service.
I'm residing it. I'm working here as a government employee. I may be posted anywhere. That is why at my permanent place of posting, because I have an objection on that point that the petitioner has failed to disclose his permanent address. In this address, since 22 March 2022, she is not here in my address. In the petition, the petitioner has given her address in my name, wife of BN Colony, in my address, wife of this Abokanan. This
Your
is not
address?
her property.
Your address?
Yes, my address has been given, whereas she is no more here. She is staying somewhere in undisclosed location and filed a case. I do not know where.
Page 43. This is, my lord, written to the petitioner number 3 by the respondents, one of the respondents. Type copies at page 44. This is in
43.
43.
Is the
This is written in Adi.
okay.
Translated copies page 44.
Yes.
This is not dated. Tu Sri Olamdoso, from our Bangkok land, you have wrongly sold 1248 acres, same plot, same area.
Yes.
To such and such. Kabang will be held on 12th of April 2023 at Bangkok, which you have wrongfully sold. So, thereafter, at page 45, they propose to hold the Kabang on 12.
Yes.
12-4. This is our objection, my lord. This is also in Adi, 45. 46, my lord, will kindly come. Respected Mongu Bango Gaon Buras, it is informed to you all, heard that regarding the land purchased by our father, Sri Sasen Sach, Bango Kabang has been called by Sri Sasen Sach. In this regard, we do not agree for conduct of Bango Kabang on our land at Bangkok because the investor said land, who is Sasen Sach, has already filed court case on 4th April 2023. And court has already issued notice on 6 April.
Hmm.
So apprise the Gaon Buras. Then in page
So
47,
this, just a minute, 44 is issued by President, original Bangkok Miku. Issued by President.
yes, my lord. There is an organization, my lord, they claim to be the original owner of the land. This is a communication made to the petitioner number 3, saying that the Kabang will be held on 12th of April.
No, Keba, this is this a Keba notice? 44
This is an information, basically.
information.
Yes. By one of the parties,
No, no,
respondents.
but the information is to Kebang will be held,
Yes.
whether the headed by this president.
No, my lord. He is one of the parties. He is informing that we have called a Kabang. So you
Okay.
come on 12th.
So Kebang will be held by the GB.
Gaon Buras, yes.
Okay, Gambara, okay.
So that's why we
So
inform the
the-
Gaon
but-
Buras at page 45.
Okay, you objected,
Yes,
saying that
Hmm.
you are not ready since the case
Yes.
has already been filed before the
yes.
civil court,
Our objection is placed before the Gaon Buras.
before the Gambaras.
Yes, we mark a copy to the ADC also.
Additional all have GBC.
Yes. all
Okay,
right.
then,
Then, my lord, in spite of that, I am skipping the other documents, my lord. These are non-relevant. We approach the ADC also. In
Hmm.
spite of that, this Kabang decision at page 51 on 12th of April. They could not have done it. Translated copy at page 54.
so this is ex parte.
Yes, ex parte also. In any case, when the matter is sub judice before a trial court, my lord,
Yes.
how can they pass this order? So my lord will set it aside, my lord. Page 54. 51 is the,
Decided what? Just let
they
us see.
decided, my lord, page 54. The
Hmm.
landowners of Bangkok land are permitted to identify and claim their respective share of land. The claim is that before 1950 earthquake, they were the original owner of the land. That is the claim. But we, the petitioners, bought it in 1996.
Certain. The boundary. What a record call for?
Record has not been called for.
It will not survive, that's true, but then record not call for party in absence of party, can you?
Party to my lord has seen the order sheet.
Hmm.
They have nothing to say, my lord. How can they have sustained this order? What is the argument, man? But if your lordship wishes to see the record, my lord, otherwise, prima facie.
It appears, prima facie, of course, it will not survive, of course, but. Yeah, so just a minute, it decided in whose favor?
In the opposition party's favor.
Opposite
Respondents
party is only represented by one,
by 2 persons.
2%.
Yes.
Both are not appearing.
No. My lord will see the 8th order, my lord. They,
Notice ensured
yes, my lord, they had entered appearance on 8/6
for both.
for both. My lord will have the order sheet. H6 order, lordship will see. Time was sought for. Mr. Ubori and another has filed the wakalatnama. I saw Mr. Ubori in the morning today.
The Wakalatnama also filed.
Yes.
Is there Wakalatnama?
I don't know, must have, my lord, they made an appearance on 8/6. My lord, to kindly have perused the 8/6/2023 order,
Okay.
second order.
Hmm.
I don't know if they have filed the wakalatnama or not. 8/6, second order. Second order, 8/6/2023. Time was sought for on behalf of Mr. Ubori.
He is also not the counsel. He is appearing on behalf of you, Bori.
Yes. And the coast list reflects the name of Ubori and Tilamu.
So granted for what? Time praise for and is granted for which time?
Thereafter, they have never appeared.
I think there is no Wakalatnama also. No color number. Yes, there is.
Yeah.
So this is the impugn order, 54.
Yes, it's a type copy, translated copy, my lord. Starts from 51. I'm not bothering your lordship with the facts of the case, because prima facie, my lord, whatever factual dispute is just there, that will be decided by the civil court.
Yes, yes.
Yes, but fact remains, dispute in respect of 1482 acres at Bangkok area is pending before the civil court senior judge.
So who is this? Column those is imposed fine of rupees.
My lord,
The decision number 4.
yes. Olom Doso, my lord, is the person who sold the land to the father
Okay.
of the petitioner
Okay,
number 1
okay.
and 2. This Kabang notice was, my lord, given to him only. This is the person, my lord, who sold the land.
Okay, not to the person to whom it was sold.
Yes.
Okay, where have you stated?
The notice,
No, yes, notice was issued to the.
page 45. Oh, no, sorry, my lord. 43.
So just a minute, huh?
43
Okay.
again.
43.
Yes.
43 is the notice.
Yes, the notice. Information, my lord.
Not the notice.
This is the information, my lord. By the respondent, number 1. Page 44 is a translated copy.
And
Page 44. This is addressed to Sri Olom Doso.
no, this is fixing the case on 12th April.
Yes, informing that the Kabang will be held on 12th of April.
And then
Not
Kabang was
fixing.
held on.
My lord,
Kabang was held on
12th of April.
on the
itself.
same day,
12th April, yes.
on 12th April.
Yes.
48.
Yes.
No, no, not 48.
51.
51. Yes, 12. Whether these Gamburas used to maintain record.
Gamudas may not, I'm not very sure. Because the 45 regulation does not require them to maintain records.
So they cannot, since they are just, they cannot be made out as party also.
They cannot be made a party.
So supposing if even if the record is to be called, how do we call?
Records will have to be called from the civil just senior division only.
But the decision of the Keba is not available with the civil just senior division.
That will not be there, but the records regarding the dispute of that particular plot that the Kabang has decided will be there, madam.
Okay.
That
So
is
then-
the only thing to be seen. Whether the dispute is
Yes,
before the
if
civil
it
just
is the
senior division
same-
or not.
If it is same, the dispute is with regards to the same.
Yes.
Then of course, it will not survive, but then.
Yes.
Since the party is also not present, so in that case, probably the record may required to be called for, to confirm.
My lord, that can be done, but from page 44 itself and the order of notice, it is apparent.
That is there, but on assumption that it may
If
be.
your lordship want to peruse the record, my lord, may call for the record.
That would be, I think, would be a right one. We'll do that. In any case, it will not survive, but then let us confirm.
My lord.
So record was not called for in that.
No, record was not called.
Okay.
Page 41, my lord, record of title suit number 8 of 2023. Ninong Ratan and another was Ovipatin and others.
Page 41.
41.
Okay. Mr. D. Pangalan, counsel for the petitioner. Petitioners, no, stuff.
Petitioners, 4 of them.
None appears on behalf of the respondent. So you also never prayed for or pressed for calling of the record?
No, my lord, I did not.
Hmm. Let us confirm.
Yes, my lord, because ultimately from the information itself, the place and location, they have admitted.
If the
that's why.
party is present,
Yeah, I
the
understand.
record may not be required also.
Yes.
Hmm.
The difficulty is they understand that they have no case, they are not appearing.
Hmm. Okay. In this case, the record of the trial court would be necessary. Accordingly, call for the trial court record of the title suit number 823 within bracket Nino Ratan and another versus Obi Pertin and others from the court of the Civil Judge Senior Division Pasigat.
My lord, can it be scanned
And-
copies?
Hmm?
Scanned
No,
copies, my
scanned
lord.
copy, huh?
The
Scanned copy.
trial might be going on.
Scanned copy of the record, okay. And the Kebang also, if comes, is okay. If doesn't, we'll try to call Kebang's record also.
My lord.
Kebang's.
Yes,
Kebang
yes,
proceeding
if
record.
possible, yes.
And Kebang proceeding record.
The bank record most probably will not be there.
Records of the Kebang proceeding before
This is, my lord, the Kabang has been signed by the chairman with the Gaonpura of Seram village. At page 52.
Okay.
I don't
Where do we find the name of the parties or number?
There is no number as such,
Number.
my lord.
Okay. So, where was the information?
My lord.
Where was the Kebang information?
Information, my lord. Information is
Gambura subdivision for information.
43, but
President.
that is not by the Gaonpura, my lord.
Okay.
My lord, will kindly see page 52. The Kabang was chaired by the Gaonpura of Seram village. One column level.
Okay.
Page 52.
Okay. So also the records of the Kebab proceeding headed by G.B. Seram. No?
Yes.
Seram of with Pasigat.
East Siang district.
East Siang district, Pasigat.
Mebo subdivision, my lord.
Mebo subdivision. List is matter of.
My lord, may Kabang records may say if available. Yes,
If
sir.
available.
If available.
Okay,
Otherwise,
if available, huh?
I don't think they have.
If available. So list is matter after 2 weeks.
2 weeks.
Okay.
Interim order.
The interim order passed on 25/4/2023 shall continue till the next returnable date, till the next date. Okay. Yes.
May I, Lordship? Lordship, here the standing counsel, Mr. Arsakia could not appear until proper instruction has been received from the NIT, Lordship, as his tenure has been expired. Lordship.
This is regarding what? No, just UFO.
I'm appearing on behalf of Arsakia, NIT, Lordship.
For the respondent.
Yes, Lordship.
Okay.
He could not appear as his appointment order is not yet renewed, Lordship.
Okay.
Proper instruction is needed, Lordship.
Standing counsel for NIT.
Yes, Lordship.
The So when it expired, in the last occasion he appeared probably.
Yes, Lordship.
You are for the petition.
Petition.
Mr.
N. Karga.
Land counsel for the petitioner is present. Stop. Mr.
B type, yeah, on behalf of us.
Land counsel inform this court that that Mr. Rintu Saikia, land standing counsel, NIT, could not appear. Would not appear in the case due to non-renewal of
Lordship.
Okay. His appointment as standing counsel for NIT staff. In view of the above, leave this matter after 4 weeks.
Obliged, Lordship.
In the meantime, confirm. If it is confirmed,
Lordship.
inform them. If you are not, if he is being standing counsel is not renewed, then they may so that they may appear appoint some other. Okay.
Obliged.
Lordship, main counsel is out. He's went to the bathroom.
Okay.
So matter may be
After
taken
some
up.
time, huh?
Yes, ma'am.
Possibly it can be, huh? 20. Acha. Yes.
Yes, others? Now, my lord, this matter, my lord.
Yes.
Yes, 3 matters, 20, 21, 22. Now, my lord, this matter can be disposed of either in 2 minutes, or if not, my lord, I may be allowed to argue on the merit of the case.
Just a minute, huh?
Yes.
This is
File meeting. Bail application. That famous.
respondent number 2 is appearing now.
Yes, yes.
Okay, just a minute.
All are represented. Now, my lord is aware, generally after filing of the charge sheet, the chances of getting bail generally increases primarily due to 3 reasons, my lord. The first is investigation is completed by the police. The custody of the accused is no longer required for investigation. 1. 2. Trial events commence. My lord, today, I think, madam, can you update the item number 2 of today's list in the session code? Okay. My lord, that now trial has
In
commenced.
the last occasion, probably we have made an observation that the case has already been submitted in the charge sheet.
It is fixed for
the pendency of this bail application shall not be barred to the petitioner. to
No, we
make
have not.
fresh
We have
bail
not able
application.
that. my lord. We have not able.
Not filed.
We have not filed because we got to a conclusion because of one incident in a POSCO case. The learned special judges were haunted by the High Court, so they are reluctant to exercise the jurisdiction.
So just a minute. Some copy of the case statement. Okay. So
Yes.
Just to refresh, let us see the FIR.
Yes, yes, my lord. That's what I want to. My lord, before that, my lord, the charge sheet has been filed on 26/6
Yes.
already, my lord.
Hmm.
Now, today, the matter was listed for cognizance in the special court.
Okay.
This I want to produce, my lord.
Okay.
So, meaning thereby, my lord, I'll come to the fact, my lord.
Hmm.
So, as I was making a submission, my lord, generally after filing of the charge sheet, the chances of getting bail generally increases for three factors.
Mhm.
The first factor, my lord, is investigation is completed by the police. Once the charge sheet is filed, my lord,
Yes.
then the custody of accused is no longer required for investigation.
Yes.
One. Number two, trial when commence may take time to complete. Therefore, it would cause injustice to accused to kept in jail for years. That is what. Two. Number three, my lord, thirdly, evidence would have already been collected by the IO. Now here, my lord, I am on to the first point of law, my lord. The apex court says, once the charge sheet is filed, then there is no requirement of further custody. There is apex court judgment. That's why, my lord, I said the first part of my argument would only take 5 minutes, my lord, if lordship agrees with me. And otherwise, my lord, I will have to go on the merits. I will demonstrate to an extent where my lord will please us to extend the privilege of bail to this accused person on the facet of Article 21 of the Constitution, my lord. Now, my lord, for a moment, since my lord is insisting that we should read the FIR, and it is always better, my lord, to do that. Now, my lord, kindly come straight to page 20.
Oh, just a minute.
20.
20. Yes.
Sorry, my lord. It is dated 3rd
Yes.
June. Officer in charge, my lord. With due respect, today on dated 3rd June 2024 at 7:16 p.m., I can get me some water. I have received a call from police personnel, SI so-and-so, Women Police Station, Itanagar, and informed that they have rescued 3 minor girls, namely so-and-so, 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 so. That is for the reasons I am not reading, my lord. There is a law on that. While conducting so-and-so at Chimpu, Itanagar, arrested 2 persons, namely so-and-so, 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 who involved in so-and-so. Hence, I, along with a member, so-and-so, rushed and reached at around 8:30 p.m. at WPS Itanagar. I provided counseling to those minors, and after counseling, it was revealed that one so-and-so brought them so-and-so, so-and-so from their native village, Boykantapur, Assam, for household work purpose, but later they were forced to do so-and-so, so-and-so by so-and-so. As per statement of so-and-so, she kept at Miss so-and-so, so-and-so, and working at one Srimati so-and-so at Itanagar, and Miss so-and-so was first kept at so-and-so, but later she was placed at Miss so-and-so, so, where...
Okay.
Grateful.
Yes, please.
If there is anything from other side, let them make submissions. So, my lord, let me recapitulate for 1 minute, my lord.
Okay.
Now, in this case, my lord will kindly bear in mind, my lord, 2 things. One, on mere suspicion of a commercial transaction made between the 2 main accused, name are there, my lord, those. And secondly, on the basis of the TIP, my lord, on the basis of the TIP, the foundation of the prosecution case is only on 2 grounds. One, only on the financial online transaction. Secondly, on the basis of TIP, my lord. And my lord, I have met the client, those clients personally in the prison also. So I have discovered a lot of materials from them, how TIP was conducted, and this 161 statement was recorded. My lord, I am coming to that. So my lord, fundamentally, the second point my lord will remember, the charge sheet has already been filed, my lord. So once charge sheet is, and secondly, my lord, that cognizance, today the matter was listed, the main accused. The case was listed for the cognizance by the special judge, honorable special judge. So, in that view of the matter, my lord, once the charge sheet is filed, my lord, then what happens? Generally, after filing of charge sheet, my lord, the chances of getting bail generally increases, primarily, my lord, due to three reasons, my lord. The first reason, my lord, is investigation is completed by the police. The custody of the accused is no longer required for investigation, one, my lord. Number two, trial, when commences, may take time to complete, and therefore it would be cause injustice to accused to kept in jail for years. If later, it would be found that he did not commit crime, he was not found guilty, and therefore to keep a balance of right of victim as well as accused, my lord, the second principle. The third principle is, thirdly, evidence, my lord, would already have been collected by the police. So therefore, the chances of destructions or concealment of evidence by accused does not arise, my lord. And, my lord, pertinently in this case, my lord, what my client told me, sir, is that, my lord, this child in conflict with the laws, my lord, these minors, as they have already submitted the additional
Lord, 1/6, all are my lord on 1/6, my lord.
They were arrested on different date.
Yes, my lord.
Dates.
Yes, my lord. As per the statement of the other co-accused, my lord. In this case, my lord, no victim is there, my lord.
All of them were arrested from Pasigat or from other?
From Assam, my lord. Some from Assam, some
On the disclosure of the co-accused, the others were arrested.
Yes, my lord, on suspicion, my lord, because some persons are working there, my lord, in Pasigat.
Just on record, whether anything they have they recovered,
No,
whether the
yes,
police
no,
has recovered anything?
Yes, Lordship, because
Seized.
Lordship, one Lordship, replica of the 9mm pistol, Lordship, which the alleged accused
Replica?
Replica, Lordship.
Okay.
Revealed that he has purchased a replica from the Paltan Bazaar, Guwahati, and has described the characteristics of the replica. And Lordship, moreover, Lordship, the alleged accused, Lordship, he the revealed that replica is in the possession of the one of the, because he purchased and he hand over to the other co-accused, Lordship. So that is the position of the other co-accused.
Purchase, Hanover, what thing?
That alleged accused, Lordship, he purchased that replica of the pistol, Lordship, from the Guwahati, and that after the revelation, Lordship, he revealed that that replica of 9mm pistol is in the possession of the one of the accomplice of Sri, this is of the Guwahati, Lordship. Then the
Not recovered any original weapons.
Lordship, that's why Lordship, he revealed that, Lordship, he has purchased, Lordship, but that
Original.
Lordship, replica, Lordship, as per his statement, is a
I'm
replica.
asking about
Lordship.
original. No.
Not replica.
Okay. Anything else?
And Lordship, as per the Lordship, this bail objection, Lordship, I of this bail, this case, Lordship, they have, Lordship, object the Lordship, this bail, Lordship, regarding that the custody of the alleged accused, not only him, Lordship, other co-accusers also, because the main accused, Lordship, that is still absconding. And Lordship, they are not
Accused in what case?
Lordship, this case, Lordship, the main accused, the main boss of them.
What they have done?
Lordship, they have, Lordship, they have,
Nothing.
they have, Lordship, tried to, Lordship, because, Lordship, before the incident, they have
Sorry,
apprehended
attempt.
before the,
Not
yes,
yet
Lordship.
committed.
Not
Not yet
attempt, my lord,
committed.
preparation.
On the way they were caught.
Lordship, Lordship,
On the way only.
Lordship.
Nothing has been committed,
But the
and attempt
Lordship,
also not there.
the materials, Lordship, they have found, Lordship, because they are, the recovery, Lordship, their phone, Lordship, their SIM card, Lordship, they all are there before the position of the.
Now, what are the incriminating material which shows that they were trying to commit the alleged offense?
Nothing has been.
Or what offense they were?
Lordship, the CCTV is also there, Lordship, because they have come for the rioting, Lordship, for the purpose of, Lordship, to, Lordship, Dekoti, Lordship, to want the soap, Lordship, they have come for in the group, Lordship. But and on information, Lordship.
Any soap?
Lordship?
Any soap or which soap?
Lordship, as per this call, Lordship, They have lordship, one shop lordship in the lordship,
Pasigat.
Pasigat lordship.
Any
CCTV is
particular
also
shop
there, lordship.
or entire Pasigat?
Lordship, the one of the shop in the Pasigat.
No specific manner. So
Lordship here, lordship, there, lordship, as per the lordship, this CD lordship, that.
How many of them were there
Lordship
at the
here,
time of arrest? Only three.
three lordship, the three surrender lordship, because lordship, they have, that's lordship, they have lordship in the way lordship, the police, after the information lordship, they have apprehended lordship, these people, and they have surrendered before the NDFB cadre, along with others who are coming to Pasigat from the Assam to rob the specific shop lordship, dealing huge transaction of the loss or first day of the month. Information shared by the one of the informer that the group were armed and has already identified the target through race lordship. Based on the information, this lordship
that is
information
there in
was
the
done,
affair, my
lordship.
lord. So no, my lord.
Who are the person who were arrested on that day?
My lord, this person, my lord, Forrest Deca, my lord, he was arrested on 4/6/2023, my
Yeah,
lord.
which one? Bail application?
Yeah, this lordship,
Item number
lordship,
23.
this they had tried to commit the dacoity at the Evergreen Lake Course wine shop lordship. Evergreen Lake, this is reflected in the CD lordship.
Just my lord, suspicion, my lord, they were coming, my lord. So no offense, my lord, committed, no attempt also there, my lord, and my lord, no victim is there also, my lord.
No, just who were the first three persons? Three persons were initially arrested.
Lordship.
Okay, who are there?
Lordship, they are
Bail
lordship.
application?
Lordship, there's a.
My lord, number one, my lord,
Basumatari.
for affair, my lord, Basan Basumatari, my lord.
Rashmi
He-
Basumatari,
because he-
Vidya Basumatari.
Basan Basumatari, my lord. Item number, my lord. Basan, item
Because
number
the
one, my lord.
petitioners are different.
Item number one, my lord.
Item one is,
Yes, my lord. Basan Basumatari,
he
my
is
lord.
the one who
And
was
my lord,
arrested on the first day.
yes, my lord. And
Okay. And-
item number two, my lord, Rosmi Basumatari, my lord. Rosmi Basumatari, my lord. Item number, my lord. Item number 4, my lord. Rosmi Basumatari, my lord.
Item
And
4.
4, my lord. And
What about 2?
And William Basumatari, my lord.
Wait,
Item
wait,
number, my
wait.
lord.
Item 1, item 4.
My lord. And William Basumatari, my lord. Item number 2. William Basumatari, item number 2. William Basumatari, item number 2.
Item 2.
My lord. Because they are working in the pilot in Pasighat, my lord. They are working, my lord, as laborers, my lord, in Pasighat. That is
All
why,
of them, all of them.
yes, in 3 persons, these 3 persons. And these 3 persons are known to them, my lord. They, my lord, want to visit Pasighat, my lord. On suspicion, my
Also there, lordship. The fourth one, Brigan
such
Rava.
preparation, my lord, and
One by one, please.
my lord.
What is your submission?
Lordship, the fourth one, Brigan Rava, lordship.
Rabba.
Lordship.
The Rabba was,
His name is also here,
he was
lordship.
arrested on the disclosure made by these 3 persons only.
Lordship.
Thereafter only.
Lordship.
On the statement of the
Lordship.
co-accused.
Lordship.
Okay, rest. So altogether, how many bail application? 5 bail application.
Lordship.
So three were arrested on that evening or morning?
My lord.
At what time?
My lord, evening.
Even,
11 hours. And information was received, my lord.
11
Thereafter,
hours.
my lord.
At the daytime?
Thereafter, my lord, they were arrested, my lord. That is the information, my lord, time, my lord. That one, so and so, 1/6/2024 at 11:10 hours, and information was received from a reliable source that a group of people, my lord. So that is the time of receive the information.
Yes,
Yes, my lord.
on the broad daylight, they were, the allegation is that they were
Coming,
okay,
a group of,
to commit docile.
my lord. Just allegation, my lord.
Okay, so this,
and for that, my lord, already, my lord, 43 days, 47 days already detained, my lord, in judicial custody. We were in police custody.
and what about this 23?
My lord, item 23, my lord, my lord, was
He is
arrested.
also member of the.
Yes, my
surrender.
lord. Yes, my lord.
And
As per allegation.
the item 3 also, he is also member of NDFB.
My lord.
All of them.
My lord. My lord. NDFB, my lord, now no more, my lord, is in his existence.
Surrendered.
Surrendered. The whole organization is surrendered, my lord. Because they had come to a compromise, my lord, with the government of India, my lord.
Whether these accused persons have stated that they made a plan to commit the crime in the particular
Yes, Lordship.
they have stated.
Lordship, they
Can you
have the long time waited for suitable time to commit the offense, Lordship.
Okay,
And they have, Lordship, after that, they have.
all of them or all of them have.
Lordship, because Lordship, this item number 23, Lordship, the accused Lordship, Prajat Deka, which they purchased the replica of the 9mm pistol, Lordship. He also, Lordship, revealed that the co-accused, Lordship, they have planned, Lordship.
And
They have pre-planned, Lordship.
just my lord, that is the 161 statement, my lord. And for that only, my lord, sufficient time we have spent, my lord, in judicial custody, my lord. What is the requirement for further judicial custody, my lord?
Okay, that was enough.
My lord, yes, my lord, and only just preparation, not attempt also not there, my lord. So only on suspicion, my lord. Nothing incriminating, my lord, has been recovered from us, my lord. Some weapons should be, my lord, recovered, my lord. That has not been happened in this case, my lord. Just a statement, my lord. And no
Lordship,
victim
the
is there,
objection
my
of the
lord.
bail, the investigation is still not completed, Lordship. That's why charges not been filed yet, Lordship.
60 days is mandatory period, my lord. We have already spent 46 days, my lord.
Can I see once if it is not secret?
Lordship,
What is the comment of the
Lordship.
investigating agency? It was on the last day of the month.
My lord, they were, my lord, produced, my lord, on 11, my lord. Last forwarding report, my lord.
But they were
Page 14,
apprehended
my
on-
lord. Page 14,
So the FIR was lodged on first.
my lord.
So
Halt.
they were apprehended on last.
My lord, they were, my lord, in police custody, my lord, for 7 days, my lord. Sufficiently, they have been interrogated. We have fully cooperated, my lord.
No, they were. Name of the person who were first arrested was Basant.
My lord.
Basant was arrested on
My lord, as per FIR 116/2024.
Basant
Basant.
and Rasmi
Next, my lord, was
and Willam.
my lord.
These three were arrested on the first day,
My lord.
but their arrest has been shown as on 2nd June.
My lord.
So the money was given to purchase firearms. So this Ramachandra Boro. Under whose possession the replica the gun is was handed over. He has not been arrested. Ramachandra Boro, not arrested.
Not arrested.
Okay. So this is only on the basis of the Ramachandra Boro not yet arrested. Okay, so just. Now they are in the judicial custody only.
My lord. After completion of police custody, they sent to judicial custody on 11, my lord. No victim that we will influence, my lord. In this case, my lord.
There is one co-accused. A local from Arunachal is also involved.
Yes, well, also investigation is not completed. There are more accused. is
But
need
you
to
see,
be-
unless there is a case against them and anything, unless any incriminating material.
Yes, my lord. Something has to be
found
recovered
against them, you
to
see,
prove the offense.
that cannot be the
Lordship,
My lord, that is the, my lord.
Lordship,
detention.
yes, Lordship, is there, Lordship,
Definite period.
Since long period of time, my lord, something has to be recovered.
because their statement, Lordship, they have.
See, they were arrested.
Police visited in Assam, my lord, several times, my lord, but could not, my lord.
So it's
recover.
more than a month.
My lord.
Lordship.
More than 4 times, my lord, visited in Assam, my lord.
Whether did you apply bail before the trial court?
No, my lord, it is not, my lord, mandatory, my lord. It is not, my lord, mandatory, my lord. That is why, my lord.
I'm asking you whether.
No,
you
no,
applied.
my lord, no, my lord, no, my lord.
You applied there.
My lord, and that time, my lord, the learned put below, my lord, was on leave, my lord. That is why, my lord, directly filed.
This time he is not on leave.
My lord.
What is the registered offense against the accused?
My lord,
And what is the minimum punishment?
390.
my lord, maximum 10 years, my lord,
10 years, Lordship.
and 60 days is mandatory
Is
period.
there any minimum?
Minimum up to minimum 7 years, my lord, up to 10 years. Minimum 7 years,
Whether
up to 10
minimum
years.
prescribed?
My lord, minimum 7 years, my lord, I think, my lord.
Okay. You are Mr.
S.S. Shikdar, my lord.
Or Mr.
S.S. Shikdar.
S.
H. Shikdar.
H.
H. Shikdar, my lord.
Sikdar. Then counsel for the petitioner. I have also heard Miss Elage, learned additional PP, public educator, state of AP, staff. You have to give me, so all, probably, there is different, each of them have some arrested on the basis of the statement of the co-accused, some on the first day. So there will be different fact circumstances of the case. No? This is
Positive Bennett, this statutory period is also not over lordship here.
Hmm?
Statutory period also not over lordship. 10 years was statutory period is 60 days lordship.
60 days we have completed
Not
already. my lord.
lordship.
In this case, my lord, item number.
Is it compulsory?
Lordship. Because lordship charge sheet has to file within that period lordship. If charge sheet has not been filed yet and the investigation is still pending lordship.
If charge sheet file will, my lord, appear before the trial, trial court, my lord, will face the trial, my lord.
And lordship, moreover lordship, here lordship, the concern this CD lordship is for the item number 23 only lordship. Before the other this lordship, they have come for the lordship in the motion stage lordship. Then lordship, they need to be CD, called for the CD separately lordship.
But
Because lordship, as per the CD content, they
territory,
have the lordship. IO is not lordship, the same CD is for the everywhere lordship.
Same in
For
one
the-
investigation, my lord.
During investigation lordship, the other lordship, they cost just to depend upon the person's lordship, their
Two different
reputation lordship.
investigation, my lord. Same investigation.
Lordship,
What is the
otherwise,
name of the accused in?
My lord, here, my lord, item number 23.
Item one, item one.
Item 1, my lord, name of the accused, my lord, Rosmi Bosumatari.
Rosmi.
Bosumatari. And my lord,
And item two?
sorry, my lord, item number 1, my lord, Bosan Bosumatari.
No, item two?
Item 2, my lord, William Bosumatari.
No, no. Item one,
Item 1, my lord, Bosan Bosumatari.
you said Rosmi?
No, sorry, my lord, Bosan Bosumatari. Item
No
number,
change.
Bosan Bosumatari.
Item two?
William Bosumatari.
Three?
3, my lord, Mrigan Rabha.
Hmm?
4,
No, no, three.
Mrigan Rabha.
Mrige.
Mrigan Rabha.
No, probably this, because this CD was called for in connection with the, or in item 23 only, probably their name
My lord.
not reflected. So I
other
need
they
to
may
be
be
given.
fixed lordship,
My lord,
lordship for the.
one investigation, my lord, one CD is.
Then it will be difficult, huh? Yes, because their name is not there.
Lordship.
IO, while forwarding the case diary in the bail application in prayer, item 23 has not made any comments in respect of the item 1, 2, and 5. So
1 to 4, my lord.
1 to 4, sorry. Although somewhere William name is there, but then others are not there. William and Basant, huh? So let the IO submit case diary in respect of the other bail applicant also. So this is the item 23 is the one. This name is
Forest Deca. Forest Deca.
Forest.
Forest Deca.
Forest lordship.
Oh, Pores.
Rest taken.
Paresh Dekha Lordship.
Pares. His name is there.
Lordship.
Yes. So this Basant took his name.
And
Basant is the Lordship, the person who initially arrested Lordship.
Hmm?
Basant is the name who arrested Lordship.
arrested on one.
Basant revealed the name of Pares. Probably. Thereafter, Pares was arrested.
My lord.
Pares was not initially arrested.
No, my
Lordship.
lord.
Okay.
He was arrested from Guwahati, my lord.
But Pares is the one who is known as Bhau. He is most powerful one among them. Hmm?
My lord.
He seems to be the most powerful among them.
My lord. Oh, my lord.
He was hired
Oh,
to
my-
intimate and grab land for their masters. Hmm?
No, my lord. Simple persons, my lord.
When Pares was arrested?
On 4, my lord. From Assam, my lord. He was arrested from Assam, my lord, on 4,
Immediately on second, third day.
my lord.
So from whom this the replica gun was recovered?
Lordship,
From Pares.
Lordship, Paresh Lordship, he revealed that he has purchased Lordship and he has handed over to the another person. It in the Lordship, their in the
But not
statement.
recovered,
Lordship.
my lord.
Because he stated that he already handed over to the other person. Lordship.
Since 1/6, my lord, police could not recover it, my lord. So just 161 statement is not sufficient, my lord, to prove an allegation, my lord. Something other material should be there, my lord.
Okay. I think 33. Huh?
Yes, sir. Lordship, let the updated city may be called for, then all the complete city, Lordship, because this here, Lordship, today only on the respect of the item number 23, Lordship.
My
the
lord, we
city
have
is
been,
here,
my lord,
Lordship.
thoroughly
This is-
interrogated, my lord.
this is
Thereafter, my lord,
application
will
under section
put this before
439
the
of
court, my
the
lord.
Code of Criminal Procedure 1973, praying for grant of bail to the accused Pares Basumatari, who has been arrested in connection with the Pasigat PS case number 77, 2024, under section 399, 120B of the Indian Penal Code. Start. Huh? Start. The case of the petitioner is that one inspector, Ige Lolen, of Pasigat Police Station, PS, loads a written FIR on 1/6/2024, inter alia, stating therein that based on 1/6/2024 at 11:10 hours, and information was received from a reliable source that a group of people comprising of 3 surrendered NDFB gathered along with others were heading towards Pasigat town from Assam to rob a specific shop dealing in huge transaction on the last or the first day of the month. Based on the information received, an extensive search were conducted and technical surveillance was mounted. The effort then led to the apprehension of 3 surrendered cadre of NDFB, namely Sri Basant Basumatari, Rasmi Basumatari, and William Basumatari. Stop. Thereafter, the police has registered the above PS case. Stop. The further case of the petitioner is that on the basis of the name revealed by the co-accused, the arrested co-accused, the present accused has been arrested by the police from where?
My lord, from Assam, my lord.
Assam, Guwahati?
Guwahati, my lord.
Guwahati from Assam.
My lord, he was, my lord, brought to the police station, Hatika police station on 3, my lord, arrested thereafter on 4, my lord. On 4, my lord. He was arrested on 4, my lord.
Okay, on 4th. With the help of the Assam police. Stop. The case diary code 4 has been produced, and I have produced the same. Stop. The record reveals that the accused Paras is Paras. Deka, Paras something we have recorded. Paras is a Deka only.
Yes,
My-
also Paras taker.
Hmm?
Paras taker.
Not Basumatari, Paras. Paras Deka. that the Pares Deka is a hired goods stroke hoodlum. He is locally called as Bhau within inverted comma BHAU, who is usually hired, to intimidate and grab land for their masters. And he is the one to whom Shri Basumadari had paid rupees 40,000 to purchase an unregistered firearms from for the purpose of committing dacoity. Stop. The record further reveals that accused Parasteka, the alleged accused Parasteka, along with 5 others, unknown persons, earlier came to Pasigat on a red colored vehicle. Whom it was identified through smart city CCTV's recording. Stop. However, thereafter, the alleged accused Paras Deka and other accomplices have fled to Guwahati. As on that day, that is on 31/5/2024. As the soap to be looted was closed and looted, closed, stop. The learned edition PP submits that in the instant case, altogether 6 persons, alleged accused persons have been arrested till date, and there are some more accused persons to be arrested, including to be arrested. So, Um, and the material the incriminating material involved in close to commit the offense, including the stolen vehicle, are yet to be recovered. The stolen vehicle are yet to be recovered. Stop. Including the replica pistol disclosed by the accused Fares Deka and the vehicle involved are yet to be recovered. Under the circumstances, if the accused person is released on bail, there is every likelihood that he may disappear the evidence, or destroy the evidence. So, moreover, the accused person, although has taken the name of other co-accused, although revealed the name of the other co-accused, but the accused only took the nickname of those accused persons without revealing the real name of the co-accused. Stop compare. Considering the allegations made against the accused and the material found on record against the accused, and the incriminating material found against the accused on record, I am not inclined to grant bail to the accused at this stage. Accordingly, this bail application stands rejected. Okay. Return the CD. Okay. And the other hard Mr. 1 to 4. Subjail Haq Sikdar, S. H. Sikdar, Land Counsel for the petitioner staff. I have also heard Miss El Hage, Land additional PP for the state of AP staff. This is bail application under section 439 of the Code of Criminal Procedure 1973 for granting regular bail to the arrested accused who has been arrested in connection with Pasigat PS case number 77/2024 under section 399/120B of the Indian Penal Code. Stop. Call for the scanned copy of the case diary. Stop. So when can you list this matter?
Next week, 23, Lordship.
Hmm?
23, Lordship, next week.
List this matter again on 23.
Lordship.
When do you want?
On Friday, my lord, next Friday, my lord.
Next
week
Friday?
My lord,
When is next Friday? Is 25.
my lord,
Okay.
26 is Friday, Lordship.
26, my lord,
Oh, 26.
my lord.
Okay, yes.
All other, my lord.
Obliged, Lordship.
1 to 4, huh? Okay.
Obliged.
Yes. Yes.
Your Lordship, by order dated 25/6/2024, updated CD was called for.
He was called for.
Yes, Your Lordship, on last occasion, there was an allegation from the IO that he is not cooperating with the investigation. Now, Lordship, so far as the present development is concerned, the IO has been changed and the concerned accused is cooperating with the investigation and he appeared and his statement has been recorded, Your Lordship. So at this stage, Your Lordship.
Oh, this is AB.
Yes, Your Lordship.
So
It's already been granted interim protection.
interim already granted.
Yes, Your Lordship.
Okay.
In my humble submission, Your Lordship, the custodial interrogation is not deemed required.
Okay. Heard Miss
A. Rai.
Learned Counsel for the petitioner. I've also heard Mr. Here, the learned additional PP. Set of AP. Para. By an order dated 6/6/2024, the accused applicant was granted an interim anticipatory bail whether he was arrested thereafter.
Your Lordship, yes, his bail was executed.
Bail was executed.
Bail executed.
Yes, that means he was shown arrested, Your Lordship.
With certain conditions. Stop. Under a granted bail, under an interim anticipatory bail with the direction to release the accused applicant in the event of his arrest in connection with the Dormant PS case number 43/2024 on execution of a bail bond of rupees 15,000 with one surety of like amount to the satisfaction of the arresting authority with certain conditions. Stop. Para. It is submitted that thereafter the accused applicant has surrendered, has been arrested on which date?
Your Lordship, initially he appeared on, Your Lordship, on 10/6/24, Your Lordship.
On 10/6/2024. And thereafter, he was released on bail on the strength of the interim anticipatory bail granted to him on 6/6/2024 on execution of bail bond. Stop. It is further submitted, the learned additional PP clearly submitted that after his arrest, the accused applicant is cooperating with the IO, the investigating agency, and is appearing before him from time to time, as and when called for. And as such, his father and his custodial interrogation is no more required. Stop. There. In view of the above, and as in view of the above, and as the accused has already been arrested and released on bail in connection with the above PS case number 43/2024, this bail application has become. Has it become infractious? No,
No, your lordship,
no,
not infractious,
Okay,
your lordship.
so the sorry, this bail application, this interim anticipatory bail, interim.
Sorry, your lordship. Sorry, your lordship. Your lordship, he has deposited the amount which has been directed by this honorable court, and he has produced the, your lordship, receipt to the concerned IO. But on seeing that the concerned IO has not arrested him, your lordship.
Not arrested?
Yes, your lordship. Your lordship, may I read the statement here? I called him again on PS on 7/7/24 for arresting him. He was cooperate me and appeared to PS, but during this time, it was again extended anticipatory bail issued by Honorable High Court UPI and received the money receipt of SBI New Delhi to pay CGM account for anticipatory bail on 26/7/27. That's why I can't arrest him due to some reason.
Why? In advance, he has done
In advance, he has deposited, your lordship.
It's not possible. Why?
Your lordship, in many occasions, what happened, your lordship, usually when the bail is granted, the accused, they directly went to the bank and they deposit the amount, and then they appear before the IO. When IO,
it is against the IO.
yes, your lordship. When IO arrests them, then they saw that they have already deposited the
No,
amount.
that will be too advanced.
Yes, your lordship.
It will be difficult. Then you should hurt the IOs.
Your Lordship, I want to submit this execution of
Interim
interim bill.
anticipatory bail is not a bail.
Yes, Your Lordship.
What is that?
Execution of interim bill.
Execution?
Yes,
Is there?
it was received by
Yes.
OC
Please pass it.
with this money receipt.
Then if you go advance after depositing, then it will hurt the ego of the IO. IO will say, no, I'm not arresting.
It was received on 12/6/2024.
What is this? No, this is too much. Unless there is a arrest. How you can arrest and you are asked to release.
Your Lordship, actually, pre-arrest bail was
How
granted
he
on.
can be released unless he is arrested? He will be released only if he is arrested.
This is the forwarding one.
Who forwarded?
Bailer.
See,
It was.
Bailar is not the authority.
It is for execution, but this is, your lordship, this is not the arrest yet.
Who is the advocate who suggested to deposit in advance without arrest?
being showing arrest, your lordship. The anticipatory bail will be affected
If
only when
you
the
have to
accused is
surrender
arrested.
first.
Yes.
After surrendering,
That's why your
then on
Lordship.
the strength of this anticipatory bail, interim anticipatory bail, you can ask for bail.
Your Lordship, actually.
Now since you have arrested, and
Pre-arrest
the
bail
court
was.
direction is that after arrest, if in the event of your arrest,
yes.
you are directed to release me. Now you release me. Then then I will ask for deposit. Then you deposit. Then only you can deposit.
Yes, your lordship.
But then you bring it, well,
In-
you hurt the ego of the IO. It is a
In anticipation, your lordship. In anticipation, they have deposit the amount, and if in case if IO arrest on them arrest, then they will execute.
You have to obtain, you see, the consent from the IO. So this is there, and then I am surrendering. You first have to surrender. Then only someone, the bailor, will go and deposit. This is too much. I think there is a serious misconception, misunderstanding.
Yes, Your Lordship.
Your
About
Lordship,
the interim anticipatory bail.
actually, pre-arrest bail was granted on dated 6/6/2024.
So what? So what?
And after that, alleged accused appear before IO.
Even
in
after
10
5 years also,
Yes.
if he has not yet been arrested, he has to surrender if he want bail. He has to surrender
Yes,
himself.
he went to IO
Then
in
what?
10th, 11, and 12, but IO was not there. So
So
in
then-
12, OC Doimuk have received the execution of interim bail. After that,
Who says what?
yes, Your Lordship.
IO, you appeared before IO. IO was
Yes.
not there.
Yes, in 10 and 11.
10 and 11, he was
Yes.
not there.
And in 12, they have received this execution of interim bail with order of this court.
So this order you produced.
Yes. After
what?
that, I don't know why they have not executed that time, but it
No,
was
no, no.
executed in 26.
They will not, unless you surrender yourself.
Yes, I
If
have
they
sent-
did, they will arrest also. They will arrest by themselves. But then if if they knows that you obtain interim
Yes.
anticipatory bail, IO may not arrest also. Sometimes it happens that IO, in
Your
order to
Lordship,
cause.
yes, in many occasions, Your Lordship, what happened here, Your Lordship, in many cases, the IO, when they appeared, even the IO, they didn't arrest, Your Lordship. They didn't show them
No,
arrest, Your Lordship.
actually, when they obtain, if the IO required in non-bailable offense, it is always better when the person obtain interim anticipatory bail. It is always better that they arrest
Yes,
and
Lord.
then release it.
And Your Lordship, at the same time, there is an issue that it is the discretion of the IO, the concerned investigation authority to
Yeah,
arrest.
that is
or
there.
not.
That is
Yes.
there. But then why to cause unnecessary harassment, knowing that he has obtained this interim anticipatory
Your Lordship,
bail,
even
and in
if
the
Your Lord-
non-serious case like this,
Your
this is
Lordship,
not
even
a
if
very serious
interim,
case.
even if without the execution of the, Your Lordship, the bail order, Your Lordship, the anticipatory will remain in effect, Your Lordship. The arrest is not mandatory, Your Lordship.
No, that is there.
Yes.
But then still, you see, this is not very serious case. So because the accused might not know the implications, and he is always in trouble.
Yes, Your Lordship.
When if I don't carry the paper,
Yes.
if I lose the paper, and for the time being, he will be kept
Let-
inside.
Yes,
Unless
later
he
on,
produce that.
later on, it will be difficult for them to get back the money, Your Lordship, which they have deposited, because since they have not been shown arrested,
Yes.
it has not been executed before the concerned IO. So otherwise, Your Lordship, the bail.
No, if they pay it in advance, they will have to suffer. Your 15,000 has gone. It happened at Pasigar also.
Yes, Your Lordship.
It was too much.
Yes.
So the money they deposited,
Yes.
they now will find out the way.
Yes, Your
And
Lordship.
they'll have to run to the court. As a no, before the bank.
Yes, Your Lordship.
And bank will also have no way
Yes, Your Lordship.
how to release. when to
Unless there is a
Because
order.
before, and unless this court give
Order, Your Lordship.
order. And then the court, as for the court, in the court, again, it's not on the court.
Yes, Your Lordship. Exactly.
So they have to request again by filing application, subsequent application. Difficult. I don't know. But then this advocate need to give a proper instruction to their own client. This is in only interim anticipatory bail. And in the case, sometimes it may require that you may have to surrender. You may ask him to surrender before and then get the bail because you are protected by the interim. And sometimes even if you appear also, IO may not release also, but then this kind of advance suggestion would be too much. So then I think this is not relevant.
No, your lordship, here, your lordship, initially they come with an apprehension that there is an allegation against them for commission of cognizable offense. On that ground, your lordship, on satisfaction that, yes, before, without arresting them, they have been directed to appear before the concerned IO. And at that point of time, since it was in anticipation, it's a pre-arrest bail, your lordship. So the interim protection has been granted by this honorable court on a ground that in the event of arrest, if they were arrested, arrested by the concerned IO investigation agency, then they shall be released on bail on furnishing fulfilling certain condition. But even if they are not shown arrested, your lordship, that's reasonable.
Only in the event of your arrest, you can produce this.
On that case, only in event of arrest, they have to execute it. But so far as your lordship, the reasonable belief is concerned, it will remain there, your lordship. So it has to be considered with its own merit, your lordship. The arrest is nothing to do with consideration.
In any case, he's cooperating.
Yes, he's cooperating. So your lordship, the
Then
interim.
the arrest part will go. Surrender, arrest part will go. The learned counsel for, the learned additional PP submits that part will remain. The accused, after obtaining the interim anticipatory bail, the accused has appeared before the eye of the case more than one occasion, and he is cooperating with the investigating agency for further investigation of the case. Stuff. Under the circumstances, that line, and in that view, and under the circumstances, the custodial detention or interrogation of the accused applicant is no more not required. So, in view of the above, the interim anticipatory bail granted to the accused on 6/6/2024 is regularized and made absolute with the same terms and conditions. So this bail application shall be read along with 6/6/2024, along with the bail order dated 6/6/2024. With the above, this bail application stand disposal. Okay.
Your lordship, CD may be returned. It may be recorded in.
Return the CD.
Yes, sir. Deeply obliged.
Deeply obliged.
Okay.
May it please your lordship. Sir, it is a pre-arrest bail application, my lord.
Yes.
The allegations are purely in civil nature, my lord. Lordship will find the FIR at page 19. It is lodged on 1/10/2023. The heading by lodging of FIR against Sri Adarsh Junjunwala, Chairman and Managing Director, JUD Siemens Limited, for non-payment of dues and fraud.
Yes.
Page 19 is the FIR. The petitioner herein, he is the CMD of Madam Meghalaya based cement company, madam. And FIR is lodged against him for non-payment of dues, madam. It is a purely civil nature, my lord, all the allegations, my lord. Admittedly, some dues are there, my lord, from the
This
company
is
side.
FIR.
FIR is page 19, my lord.
So this page 19 is FIR.
Yes, my lord. Starts from page 9. It's a long FIR, my lord. Type copy.
Long, very long.
Very long.
Very
my
long.
lord.
Not only long, it's very long.
This is about 4 pages, my lord.
What is the basic allegation is?
Basically, my lord,
Okay,
the company hired vehicles, my lord. Therefore, my lord, some payment was due, my lord. There was discrepancies in the bill, my lord. Their demand is very high, so it could not be paid, my lord.
No.
And an amount of rupees 13,80,000 was paid.
Against
The CMD of the company.
Chairman of the management.
Chairman come managing director of the company.
He was to, for what the payment was to be?
My lord, it is reflected from the, my lord, page 19, that during October 1921, I was approached by Sri Tarsem Zindal, husband of so-and-so, proprietor of PTK Enterprise, village so-and-so, Bhalupung, who assists his wife in business of PTK Enterprises with proposal to provide 3 numbers of Hiwa 10-wheeler dumpers on rent or lease to them for employing them with UD Mining Network Services Private Limited, so and so, Jointe Hills, Meghalaya, for a period of 5 years. But contract was for 10 years, my lord. After 1 year, my lord. Subsequently, my lord, what happened, my lord? They withdraw the vehicles, my lord. There was discrepancies, my lord, in the bills, my lord. So their demands, my lord.
Mr.
The civil nature, my lord, contextual
It
basis.
appears that money transaction only.
Yes, your lordship. At this stage, your lordship, what my humble prayer would be, your lordship, call for the case diary so as to ascertain whether in this transaction, whether there was a commission of dishonest, there was a dishonest intention or fraudulent action.
Mr. You are Mr.
JC Google.
JC Gogol, and counsel for the accused applicant. Staff, I have also heard Mr. Theatre, landed additional PP, state of AP, staff. This is an application under section 438 of CRPC 1973. Praying for grant filed by the accused applicant, written, praying for grant of free arrest bail, apprehending his arrest in connection with Balupung PS case number 19/2023 under section 420/406 of IPC. Where have you stated that you apprehend your arrest?
My lord, it is there, my lord, police of my lord Bhalupung police station, along with the my lord police, Assam police, my lord, they searched the petitioner's house, my lord, on 12, my lord. It is in paragraph 7, my lord.
Okay. 4.
12/7/2024.
The scan copy. Scan copy.
Yeah, scan copy will work. Yeah.
Of the case diary. Who else is the party? Only state. Okay. So. Fixing the next date on when?
Your lordship, after a week, your lordship.
Okay, after 26. 26.
Okay, your lord, 26.
26.
In the meantime, I may be.
In the meantime. Till the returnable date. In the event of the accused applicant. What is his name?
Others
Junjunwala. Junjunwala being arrested in connection with the Bhalupung PS case number 19, in connection with the above Bhalupung PS case number 19/2023 under section 420/406 of IPC. He shall be released on interim anticipatory bail on execution of bail bond of rupees. Normally, what is the transaction money involved?
My lord.
What is the amount involved?
Amount, my lord, they are claiming, my lord, 85 lakhs.
85
Actually, our bill is shows, man, our transaction is something different.
50,000. Huh?
With the civil dispute, they can, my lord, sort
on
of.
execution of a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority, with the further condition that the accused applicant shall cooperate with the IO of the case and appear before him as and when called for, and further that he shall not hamper or tamper with the evidence of the case. Start, huh? List is matter again on 26. Okay.
Your lordship, let him appear within 3 days from today.
My lord, appearance part, my lord, I am submitting, my lord, para 8, lordship, can you see, my lord?
The accused be directed to appear
Before the IO, your lordship.
Okay.
My lord, we are ready, my lord, paragraph 8, kindly, page 12, lord, we are receiving threatening calls from the, my lord, other side, my lord. We are receiving, my lord, he is receiving threatening calls, my lord, from the other side, and his, their, my lord, person is, my lord. So, my lord, proceeding to Bhalupung, it will be difficult for him, my lord. He can, my lord, in nearest
Then will not grant.
Test, my lord, he can, my lord, record his statement.
How
Otherwise,
it is possible?
my lawyer, if lordship directs, my lord. Otherwise, my lord,
No,
proceeding,
yeah.
even he can come to Itanagar, my
Your
lord.
lordship, in that case, if threatening is there, let them file an FIR for that, your
That
lordship.
is
To that
true.
Like
effect.
Itanagar, my lord, he may come, my lord, in.
This is affair against you. You
My-
file affair against him.
Okay, my lord.
Take revenge.
Yes, within 3 days, your lordship.
Okay.
From today.
3 days, hello, within 3 days,
Okay,
it will
then,
be.
then in that case, on execution of bail bond of rupees 50,000, and then with the following conditions, then one, that he shall appear, that one, and then two, and then the third will be the accused. Say, applicant shall appear before the eye of the case within.
When you want to appear
My
there.
lord, within 7 days, otherwise, my lord, he have to come from
Within
Meghalaya.
within a week from today.
Within a week from today.
Okay.
Before the next date, your lordship fix.
My lord.
Within a week.
Then,
That
madam,
comes
10
within
days.
a week only.
Okay, your lordship.
Okay, list is matter on 26.
Highly
Okay.
Oblige, sir.
Huh? How many meters? Oh, it will be difficult.
My lord, I am for item number
Sorry. 19. No, it will be
19.
difficult. No, this will be listed day after tomorrow, huh?
My lord,
Best-
my parents, my lord, we have filed one affidavit, my lord, that may be come along with this matter, my lord.
What affidavit?
Additional affidavit, my lord.
In bail application?
Yes, my lord. AB, my lord, item number 19.
List it, okay. Is prayed for by the Lana Council for the petitioner. List is matter on Thursday, huh? Along with the additional affidavit filed by the applicant.
Petitioner.
Okay,
Petitioner.
petitioner. Okay. That is in 19, huh? And other? Yeah, also.
Deeply obliged, my lord.
Okay.
Item 10.
10. For the 10 is over.
Your lordship, no need from the other side. Well, my lord, it may be listed day after tomorrow, my lord. This is appeal, my lord, first appeal.
This is in earlier PT Taras case. You remember the number?
Yes,
Correct.
item number 20.
That is in that. Yes, this.
Item number 12, my lord, this
This
is.
is 12.
Yes, regular first appeal, my lord. It may
Oh,
be
it was
listed day
passed
after.
over.
Tomorrow. Yes, ma'am.
Mr. Binta.
Yes.
Will not be able to take up.
Yes, sir, day after tomorrow, my lord.
Okay. Is prayed for by the Rana Council for the party list. Okay. Due to paucity of time, the matter could not be taken up today. Is prayed for by the Rana Council for the petition. List this matter again on
18.
What is this matter? Is it urgent?
My lord, yes, my lord. Dear.
18 or next week?
Next week, my lord.
Okay, next week. Okay.
Public.
27. So this, I think in 27, I am connected. Who is there? So list this matter before any other bench without me. Okay. Criminal appeal. So here I am here. Here, have you seen? No. I have seen. My name is there. Charge frame, evidence reported.
Okay, then not before your lordship.
Okay. Any other?
Any
This
other?
one.
Deeply
Okay.
obliged.
Yes. Yes, what is this matter about?
I put a respondent, we need some time to file.
My lord. My lord.
Yes.
We are for the petitioner. This is a case of grave concern.
Objection not yet filed.
Yes, my lord.
My lord, because interim stay is not granted to us, it was rejected. In this case, interim stay was rejected. So this matter requires expedite hearing. So earlier occasion, your lordship has directed them to file their objection within 2 weeks. They sought 4 weeks time. And the appeal is slated for hearing, my lord. And this is a case of perjury. They have stated false statement, given false statement under affidavit, giving false ground. seeking condonation of delay. And that is very much apparent. We have exposed them with documentary evidence, my lord. He's a multi-millionaire, and he's stating before the court, he has the audacity to state before the court on affidavit that he is a poor, below poverty line category. He owns a Bolero camper vehicle, which is worth 1 million. And other statement that he did not receive the copy, we have produced their document, which shows that copy of the judgment was received by them. So this was categorically exposed. So it requires urgent hearing around, because the appeal is slated for hearing.
So there is no stay.
No, stay was rejected. my lord.
Okay. Then
Probably my junior failed to place the case properly on the day of motion itself. So the interim stay was rejected with a speaking order
Okay, now your submission is?
for hearing, my lord. Because
Hearing.
it does not require, because it's their falsity.
Okay. Also for the sole respondents.
So I'm praying.
You file objection?
Yes, my lord. 2 weeks, my lord.
No, my lord.
2 weeks.
Yes.
My lord,
No, because you say, what is, the prayer is?
prayer is, my lord, to set aside the impugn order.
Hmm?
To set aside the impugn order of the.
Why the impugn order?
Impugn order is on page
What order was passed? What is the impugn order?
20, page 21, kindly see, my lord.
21.
21, my lord.
What is the impugn order?
The
The operative portion?
operative portion, my lord. It was
This
page
is in the documents.
22. Just a minute. Last paragraph.
So by this impugn order, what, yes,
Yes, my lord. The appellant has stated that this is, so the delay condonation was granted.
delay condonation was granted.
Granted.
To-
Delay was condoned.
Delay was condoned by this impugn order.
Yes,
So you are against the condonation of delay.
that order, yes, my lord. Because the grounds stated by
delay-
them, my lord,
Delay was condoned by the
by the
trial
appellate court, appellate court below.
appellate court.
Yes, my lord. There was a delay in preferring the appeal.
Senior division is appellate court.
Yes, my lord.
This order,
Yes, my lord.
delay was condoned.
Yes.
You have come against this condonation of
Against
delay.
this delay, order, impugn order.
Why?
Because, my lord, they have given, they have stated grounds for delay. They have given 2 grounds. That because of they belong to below poverty line category, they face financial constraint, and it requires them time to come to the court to collect some money, to arrange money. That's the delay. But we have proved that he is a multimillionaire.
What is the fact of the case then, dispute is?
Dispute, but there was a original case was of land dispute. It was, judgment was pronounced by the customary court. Against that judgment and order, they preferred an appeal. And while preferring the appeal, there occurred a delay of 74 days.
And probably it is always better to get the case decided. on merit.
My lord,
Yes, ma'am.
I am not on the case to be decided on merit.
Right.
But the thing is,
Hmm.
if they had committed perjury,
Hmm.
it is apparent, we have proved it. If they have committed perjury, if they have given false statement on
Is there no
affidavit.
provision for review?
Yes, ma'am. No
My lord.
provision for revision, my lord.
No, no,
They
no,
have to prefer appeal, my lord.
no, no,
No, no, I am asking. you.
Condonation of delay, my lord.
This is a CRP. This is a
Yes.
civil revision petition.
Yes, yes.
So when they have stated false affidavit,
Mhm.
falsity is very much apparent. So they are liable to be prosecuted for contempt of court.
You file the.
This is a serious matter, my lord. Because
file-
perjury cannot be condoned,
Right.
condoning the
So-
delay.
Obtaining order
No,
by giving false evidence,
my lord.
false statement would be difficult.
That's
But
the
yeah,
for the
perjury.
court, especially in the court.
Yes, ma'am.
And they have not denied it.
No, that will be difficult. Huh?
So it may be stated, my submission is that it may be fixed for hearing because stay is not granted to us. And
Or revision
Hard,
lies.
hard, Mr.
G Saikia, my lord.
Sekia.
G Saikia.
Okay, Learned Counsel for the petitioner. Also heard Mr. Deep Pitcher, Learned Counsel appearing on behalf of the respondent. Stop, Mr. Pitcher. So, just a minute. Pitcher prays for further
2 weeks time.
2 weeks time
Alright.
to file objection.
Because earlier time, they sought time, they failed.
Hmm.
Whether the revision itself is maintainable, my lord. That
Yes,
has to be
of
seen, my
course.
lord. The
Oh,
revision, my lord, is the
let it be
premise
heard.
whether the learned court below has a
Yeah.
jurisdiction, my lord.
The prayer is allowed on the condition that this is the last. This shall be the last opportunity,
My lord, yes.
chance to file.
Well, the matter may be fixed for hearing because
Okay.
it requires.
File, to file objection, stop, Is prayed for by the land council for the party. List this matter on
16th of August
16.
for hearing, my lord, because it
16
stay has been.
for admission hearing.
Yes, ma'am.
Stop, In the meantime, the respondent shall file their objection.
Ma'am.
Okay.
Yes.
Mm.
Obliged.
Obliged.
The objection and serve a copy to the land council for the petitioner at least 2 days before the next date. Okay.
Obliged, ma'am.
30.
My lord.
Okay, the due to paucity of time. Yes,
Lordship.
Oh.
There is a small request, my lord.
Hmm?
There is a small request on our part, my lord,
Yes.
that this matter has been adjourned time and again. So if it could be taken up shortly on Friday, my lord, 19th.
Friday would be difficult. It will be the last day for me.
Lordship, it
So
maybe
next
on
week,
23.
we'll fix the date.
23.
23.
Fix it,
Let's
yes,
wait for
yes.
by both the land council for the parties. List this matter again on 23. For this is hearing.
For hearing.
Hearing. Okay, for hearing. Okay.
Yes.
Yes.
Much obliged.
Deeply obliged. Okay, no time. Yes, ma'am.
My lord, this matter may be listed for
Sorry.
3 weeks.
Good time. Okay. Both the land council for the both the parties are present. Due to paucity of time, the matter could not be taken up today. As prayed for by both the land council for the party. This is matter again
After 3 weeks, yeah.
after 3 weeks.
Yes.
And this is matter after 3 weeks.
3 weeks we.
2 weeks.
2 weeks. Let
2 weeks. Okay. Okay.
Obliged.
Obliged.
Your Honor, this is a quashing for the for the cases which was trial, which was pending before CJ.
You are for the
I for
petition.
I'm the petitioner. Your Honor, matter may be listed on Friday because on the last.
Friday.
Actually, your lordship, the stay order was granted on 6/6/2023.
Quashing petition.
Yes.
What is the offense involved?
355. Moreover, your Honor, 3 witnesses has been already examined.
Examined.
Yes, informant and.
Let the trial conclude.
Your Honor, actually, in the cross, they haven't found any.
So that is why,
That's why- Your
there
Honor,
was
that's-
nothing against you. Then why to worry?
Your Honor, actually,
Okay,
the
let's wait for by
petitioner.
land council for the petition. At least this matter again on Friday. Okay,
Much.
finish. This is on the last bail. 23. Inserted in 23.